Adetona.
Unfortunately, I didn't know why the establishment established or the affidavit was established.
Yes.
But my Lord, even if
I hope the council in number NICLA 01-2012 are ready. Are you here in court?
Yes, my Lord.
Very well. We'll start with that. We'll finish it quickly and then go to the other one. So please let me take your appearances.
All right.
Appearances.
May it please this honorable court.
Yes.
J.A. Oladapo. J.A. Oladapo. My Lord, Oladapo is spelled O-L-A-D-A-P-O.
Okay, no K. Okay.
Yes, my Lord, my appearance is for the claimant in this suit, my Lord.
Okay.
Thank you, my Lord.
Very well. Yes. Who is for the respondents? We are talking of David Adetona and Farmer Dewa. Who is on the other side? Who is on the other side? For the first defendant, Amaka Louis, are you here today? Yes, Mr. Oshikoya, are you here today? Well, no representations yet.
My Lord, I
yes.
believe there is no representation on the other side, my Lord.
Okay. Which one? Okay. So the first one is J.A. That was Esquire for the claimants.
Yes, my Lord.
Yes. So nobody is for the respondent presently.
Yes, my Lord.
Okay. So I'll go straight to the ruling. Now, this is the ruling of the court on the application dated the 14th day of June 2022 and filed on the same date by the second defendant applicant, brought pursuant to rules of court and constitutional provisions, seeking the following. 1, an order of this honorable court declining jurisdiction to entertain the suit as constituted against second defendant. In the alternative, an order of this honorable court dismissing or striking out in limine this suit as constituted against the second defendant on grounds that it does not disclose a reasonable course of action. The last prayer is the omnibus prayer, and the grounds upon which the application is brought are as contained on the face of the motion paper. The application is supported by a 4-paragraph affidavit proposed by one Peter Silvanus, designated as a litigation officer in the law firm representing the second defendant applicant. In his written address, the applicant formulated 2 issues for determination, to wit, whether this honorable court has subject matter jurisdiction to entertain this suit as constituted, and secondly, whether or not the claimant's suit discloses a reasonable course of action against the second defendant. The learned counsel to the applicant contended that given the provisions of section 251 sub 1 paragraph R of the 1999 Constitution as amended, and the entirety of the claimant's pleadings, this court lacks subject matter jurisdiction to entertain this suit as constituted by paragraph 30 of the claimant statement of facts. The claimant had raised questions relating to the validity or otherwise of the administrative action of the president, and it is the Federal High Court that has the jurisdiction.
With profound respect to this honorable court, Tolulope is my name, Lord. Very well, my lord.
Okay.
My appearance is for the applicant. I have two applicants.
Yes. Very well. Tolulope Ige Esquire. For the applicant, you said. Very well. The learned counsel to the applicant contended that given the provision of section 251, sub 1, paragraph R of the 1999 Constitution as amended, and the entirety of the claimant's pleadings, this court lacks subject matter jurisdiction to entertain this suit as constituted. By paragraph 30 of the claimant's statement of facts, the claimant had raised questions relating to the validity or otherwise of the administrative action of the president, and it is the Federal High Court that has jurisdiction to entertain such. It referred the court to the case of NEPA versus Idigbe, reported in 2002, 18 Nigeria Weekly Law Report, part 798, page 79 at 95. On issue number 2, counsel submitted that the claimant suit does not disclose a reasonable cause of action against the second defendant, as the that alleged termination of his amount by paragraph 23 and 30 of his pleadings has shown that his appointment was terminated by the president and not the second defendant, who is an agent of a disclosed principal. Counsel then urged the court to decline jurisdiction in respect of the claim against the second defendant and strike out the name of the second defendant from the suit. In opposition to the second defendant's applicant's preliminary objection, the claimant filed a 5-paragraph counter affidavit deposed by one Mayowa Adebayo, designated as a litigation clerk in the law firm representing the claimant. The claimant, in his written address, formulated 2 issues for determination, and these are: 1, whether or not the subject matter of this suit falls within the jurisdiction of this honorable court. 2, whether or not the second defendant applicant in the instant suit is a necessary, desirable party to the instant suit. The learned claimant's counsel contended that the jurisdiction of a court is conferred on it by the Constitution of the and the establishing act, referring the court to My Fata versus Upper Sharia Court, Kofo, Kudu, and others, reported in 2017. Citation fully supplied. Section 254C of the 1999 Constitution of the Federal Republic of Nigeria, Section 7 of the National Industrial Court Act confer exclusive jurisdiction in labor matters on this court, and the pleadings of the claimant shows that the matter at hand is a labor issue, as it borders on wrongful dismissal of the claimant. The case of NEPA versus Idigbe Supra is inapplicable to the instance suit, given the decision in CBN versus Odo, reported in 2020, LPELR 50290 CN. On issue number 2, learned counsel submitted that the second defendant applicant is a necessary and desirable party with requisite interest in this suit as the administrative head of the first defendant, Azubike versus the PDP and others, reported in 2014, LPELR 22258, Supreme Court. Counsel urged the court to dismiss the application of the applicant. The second defendant, in his reply on points of law, contended that paragraph 3, sub 2 to 9 of the claimant's counter affidavit contravenes section 115 sub 1 of the Evidence Act as they amount to hearsay, and should be struck out, referring to the case of Hakai Limited and another versus Sterling Bank, reported in 2019, LPELR 47638 CA. Council contended further that Section 254C of the 1999 Constitution as amended is not applicable in the instant suit, and Section 251 of the 1999 Constitution of the Federal Republic of Nigeria as amended prevails over Section 2541, 2541C, 254C sub 1, referring to Ndaba Nigeria Limited versus UBN, reported in 2009. Citation supplied. The cases of Salami versus NJC and CBN versus Odo Supra, cited and relied upon by the claimants, are distinguishable from the instant suits and are inapplicable. Assuming jurisdiction would then amount to denial of the applicant's right to fair hearing. The claimant did not respond to the issue raised of absence of reasonable cause of action against the second defendant. This is how it was resolved. Upon a careful consideration of the facts and circumstances of this case, the processes filed and submissions made in support and in opposition of the instant application, the court distills the issue below for determination. And that is to say, in the light of constitutional provisions and pleadings of the claimant, does this court have jurisdiction to entertain this suit? And is the second defendant a proper desirable party to this suit? Before proceeding further, may I quickly address the issue raised by the applicant's counsel that paragraph 3, sub 2 to 9 of the respondent's counter affidavit contravenes section 115 sub 1 of the Evidence Act 2011 as it amounts to hearsay and should be struck out. It is the law that where a person who deposits to an affidavit is not abreast of the facts of the case, the party in whose favor the deponent deposits to the affidavit can give the necessary information or data to the authorized deponent on behalf of the party in the action. All the deponents in such situation would do is to show that he has the consent of the party in litigation concerned and believes in the facts passed to him by the disclosed party or person. See the cases of Njoemena versus Uboma and others reported in 2014. And also Dupian Long and others versus Darie and another reported in 2007. Citations fully supplied. So where a deponent to an affidavit belief is derived from information received from another person, the name of his informant shall be stated, the reasons, reasonable particulars shall be given respecting the informant, and the time, place, and circumstance of the information. Hearsay evidence is generally inadmissible as it has no probative value. However, hearsay is an affidavit is admissible, provided the source and ground of information or belief are disclosed therein. See the case of Ab versus Oturie, reported in 2019, and also Sambo versus Nigeria Army Council, reported in 2017. Citations fully supplied. The deponent gave information about the source of his information, the place, time, and informant. Was the information given by the deponents to the claimant's counter affidavit meant to establish the truth of what was contained in the statement, or to establish by evidence not the truth of the statement, but the fact that it was made? The depositions in paragraphs 3 sub 2 to 9 of the claimant's counter affidavit are basically a reproduction of certain portions of claimant's statement of facts. These facts are therefore not new to either the court or to the appellant. They are, in my view, relevant to emphasis or re-emphasize the claimant's course of action and not necessarily made to establish the truth of his employment history. In the case of Samaila versus State, reported in 2021 for Nigeria Weekly Law Report, part 1767, page 528, the Supreme Court on the issue of admissibility of hearsay evidence held inter alia, quote, whether evidence of a statement, oral or written, by someone other than the witness testifying before a court is inadmissible as hearsay evidence depends on the purpose for which the evidence is given or tendered by the witness in court. In effect, the focus is on the purpose or use of the statement rather than the mere fact that it was made by a person not called as a witness. If the only relevance of the statement is the truth it asserts, it is a hearsay statement. Where, however, the statement is relevant for some purpose other than the truth of their contents, it is not a hearsay statement, and it is admissible in evidence. Having found that the purpose behind paragraph 3(2) to 9 of the claimant's counter affidavit appears to be emphasizing the claimant's course of action, I find and hold that same is not hearsay. Learned applicants' counsel submission in this regards are hereby discountenanced, and the issue is thus resolved against the defendant's applicant. Learned applicants' counsel had contended that the claimant's counsel wrongly cited the case of Salami versus agency and referred to portions of the said decision incorrectly. The position of our laws is well settled that counsel need exercise care in citing authorities and are to, in reciting relevant authorities, refrain from attempting to mislead the court. See the case of Nigeria Custom Service versus Bazuye, reported in 2006. 3 Nigerian Weekly Law Report, part 767, page 303. See also the case of Idigbe versus Ibe Kandu, reported in 1998. 7 Nigerian Weekly Law Reports, part 558, page 486. While it may be noted that no human is above error, counsel has a duty to be more careful in providing all the relevant information in respect of cases he relies upon and not to misconstrue the findings of a court. A word is enough for the wise. Jurisdiction is the lifeblood of any adjudicatory proceedings. Without jurisdiction, no matter how well a proceeding might have been, such proceedings will amount to a nullity. See SPDCN Limited versus Anaro, reported in 2015, and also Obijaku versus Obijaku, reported in 2022. Citation supplied. The jurisdiction of a court is conferred by constitutional provisions and its enabling acts, and not by ingenious arguments and submissions of counsel. See Kanyip versus PDP, reported in 2005, and also Okarika versus Samuel, reported in 2013. See also Sulaiman versus FRN, reported in 2020. Citations all fully supplied. A court, in determining whether or not it has jurisdiction, will look closely at the claimant's originating processes and pleadings, that is the claimant's writ of summons and statement of claim, and not the pleadings of the defendants. See Marine International Limited versus Ayetoro Bay Agency, reported in 2016 for Nigeria Weekly Law Report, part 1502, page 313. Learned Applicants Counsel contends that this court lacks subject matter jurisdiction to entertain the suit as presently constituted, as in his opinion, the suit borders on the validity or otherwise of an administrative action of the president of the country, for which, according to him, by virtue of section 251, sub 1, P, sub L, P, R of the 1999 Constitution as amended, the Federal High Court has exclusive jurisdiction over. The Claimants Council, however, contends that from the facts in the claimant's pleadings, this suit hinges on labor issues, which section 254C, sub L of the 1999 Constitution as amended, and section 7 of the National Industrial Court Act confer jurisdiction on this court. Section 251, paragraph L, P, and R of the 1999 Constitution as amended provides thus, quote, notwithstanding anything to the contrary in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of National Assembly, the Federal High Court shall have an exercise jurisdiction to the exclusion of any other court in civil causes and matters. Then paragraph P says, the administration of the management and control of the federal government or any of its agencies. Then R says, the administration of the management and control of the federal government or any of its agencies, unquote. On the other hand, section 254C, L, paragraph A and K of the 1999 Constitution as amended provides thus, and I quote, notwithstanding the provisions of sections 251, 257, 272, and anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil matters and manners, in civil causes and matters, A, relating to or connected with any labor, employment, trade unions, industrial relations, and matters arising from workplace, the condition of service, including health, safety, welfare of labor, employee, worker, and materials incidental to, hereto, or connected therewith. Then sub-K said, relating to or connected with disputes arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee, worker, political or public officer holder, judicial officer, or any civil or public servant in any part of the Federation and matters incidental thereto, etc., unquote. Section 7(1)A, A1 and 2 of the National Industrial Court Act confers on this court exclusive jurisdiction in civil matters relating to labor, environments, and conditions of work. Our rules of interpretation stipulate that where the wordings of a statute are clear and unambiguous, they should be given the plain and ordinary meanings. See the case of Lawal versus EFCC, reported in 2020. See also Dangana versus Usman, reported in 2013. Citation supplied. The wordings of section 251 LBR, that is paragraphs, then 251C, 1A and K of the 1999 Constitution as amended, and section 7(1)A, 1 and 2 of the National Industrial Court Acts are clear and unambiguous and should be given their plain and ordinary meanings. The provisions of section 251L, that is paragraph LPR of the 1999 Constitution, as amended, confers on the Federal High Court exclusive jurisdiction in civil matters relating to the administration, management, and control of the federal government and any of its agencies. Section 251C of the same Constitution, on the other hand, confers on the National Industrial Court of Nigeria exclusive jurisdiction in civil matters relating to and connected with, amongst other things, any labor, employment, trade unions, industrial relations, and matters arising from workplace, the conditions of service, disputes arising from payment or non-payment of entitlements of any employee, worker, civil, or public servant in any part of the Federation, and matters incidental thereto. As stated much earlier, the court, in determining whether or not it is seized with requisite jurisdiction to entertain a suit, like the instant suit, looks at the claimant's originating processes and pleadings. In this case, the claimant's complaints and statements of facts, and not the defendant's defense or its interpretation of the claimant's suit. Barely stating, as the claimant has done, that the president does not have the powers to terminate his employment is not indicative or conclusive proof of challenging an administrative decision, but merely stating facts on who has the powers to hire and fire the claimant from his appointments. The second defendant applicant has not placed any evidence before the court that there was an administrative decision that involved the president of the Federation, which led to the disengagement of the claimant from the first defendant's employment, or that the person that signed the letter of 4th of October 2011 acted as an agent or in the instruction of the president. No memo to this suggests this and has been placed before the court. In relation to some of the claims of the claimant, the law requires he places before the court evidence of who has the power to hire him as an employee and who has the power to terminate his employment, and alludes to the facts that demonstrate that the termination of his employment was not in keeping with the conditions of service or terms of his employment. This, the claimant appears to have done by his averment at paragraph 23 and 30 of his statement of facts, amongst others. These and other portions of the claimant's pleadings are indicative that the claimant's suit is related to and connected to labor, employment, conditions of service, industrial relations as a civil servant, and matters incidental thereto. The claimant's claims do not, contrary to what the applicant wants the court to believe, show that it is centered on the administrative action of the president, or that it seeks to question the validity or otherwise of a decision of the federal government. It is the defendant that appears to be bringing this to the fore without evidence to support the position. The signatory to the letter dated 4th October 2011 would only be an agent of a disclosed principal when there is a correspondence or any other evidence depicting that he acted on the instruction of the on behalf of the alleged principal. In this case, there is no such evidence. That is, there is no evidence before the court to show that the permanent secretary was instructed by the president to write a disengagement letter to the claimant. Acting on the applicant's submissions, interpreting the contents of the letter dated 4th October 2011 at this stage of the proceedings would not only occasion a miscarriage of justice, but would amount to giving room to speculation and delving into the substantive matter at an interlocutory stage, which the law frowns at. The arguments by learned applicants counsel that Section 254C of the 1999 Constitution as amended is inapplicable in the instance case, in my respective view, seems to be misplaced in the instance of the obstructive facts that the claimant's pleadings that this suit is related to or connected with employment labor matters. The way and manner of the termination of the claimant's employment seems to me to be what is under contention, particularly the purported non-compliance with the first defendant's condition of service in doing so. The issue of contesting the validity or otherwise of the administrative decision is thus premature and cannot be adequately and dispassionately looked into at this stage of the proceeding. Accordingly, this leg of the defendant applicant submission is resolved in favor of the claimant's respondent and is thereby discountenanced. Trying to resolve the issue would, one way or the other, lure the court into delving into the substantive issue of this at this interlocutory stage, which the law prohibits. See the case of Agwu versus Julius Berger, Nigeria Limited, PLC, reported in 2019, and also Haladu versus Access Bank, reported in 2021. Citation supplied. I therefore find and hold that this court has the subject matter jurisdiction to entertain this suit as presently constituted, given the facts and claims of the claimant as per his statement of facts and the provisions of section 254C 1999 Constitution as amended. Section 7 of the National Industrial Court. I shall find and so hold. On the issue of the provisions of section 251 prevailing over section 251C of the 1999 Constitution as amended, may I state that when the term notwithstanding is used in a section of the statute, it is meant to exclude an impinging or impending effect of any other provisions statutes or other subordinate legislations, so that the said section may fulfill itself. The use of the word notwithstanding means that no provisions of the Constitution or statute shall be capable of undermining the said section. In opening phrase, notwithstanding anything, in quotes, in the statute is a phrase of exclusion which accords the said statutory provision preeminence and having a precedence over and above other provisions in any other enactment. See the case of Uyo local government, the Akwa Ibom State, reported in 2021. Citation supplied. The applicant has made heavy weather of the connotation and implication of the state, notwithstanding anything to the contrary, to support his contention that by reason of this phrase, the provisions of section 2251 of the 1999 Constitution prevails and or supersedes the provisions
15 December 2020. Which is that this respondent don't have any representation, any concern in respect of complaint made by the judge again. In what way? Again, the six respondent.
Melody, your mic is muted.
Yeah, I can't hear you. Okay, now.
Oh, maybe it was admin that muted it. Are you hearing me now?
Yeah, we can hear you.
Do you hear me now? Okay.
My lord. Yes, my lord, we can hear you now.
Okay, now. I don't know where will I just go on. Notwithstanding the provisions of section 251 257, 272, and anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by any act of the National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil cases and matters. It mentions that notwithstanding the provisions of sections 257 and 2, in the National Industrial Court shall any other court in civil cases in the matters listed in a subsection underlined for emphasis. Do you see hear me?
You can hear
Are
you.
you still hearing me?
Yes, my lord.
Hello? Am
Yes,
I
my lord.
muted?
Can hear you.
My lord.
Yes, my lord, we can hear you.
Can hear you.
Yes, my lord, we can hear you.
Yes, we can hear you, my
Okay.
lord.
Very well. So this in itself gives preeminence and precedence over other sections, particularly the sections expressly mentioned in section 254C, 1 of the 1999 Constitution, of which section 5251 is one of such. It is one of the canons of our rules of interpretation that in all cases of interpretation of statutes, the interpretation should be according to the intent of them that made the law. It is the wordings of the Constitution itself that it is to be interpreted and applied, and this wording can never be overridden by the extraneous principles of other provisions which are not explicitly incorporated. See the case of Our Line Limited versus SCC, Nigeria Limited, reported in 2009, 17 Nigeria Weekly Law Report, part 1170, page 382 at 409. The Constitution before the amendment, the Constitution before its amendments that enacted section 254C1 of the 1999 Constitution emphasized that there was one of the parties to a dispute, emphasized that where one of the parties to a dispute is the federal government or any of the agencies and the disputes borders on any subject matter listed in section 251 sub 1 of the Federal High Court. The Federal High Court had and was to exercise exclusive jurisdiction. The duration of the statute may be perpetual, but its functions and functioning change over time. The failure to recognize this is what birthed the applicant's arguments in this regard. The proviso of section 251C sub 1 is categorical on the conferment of exclusive jurisdiction on civil matters in relation to, amongst others, labor, employment, conditions of service, industrial relations on the National Industrial Courts, notwithstanding the provisions of section 251, 257, and 272 of the 1999 Constitution as amended. See the case of Coca-Cola Limited, Nigeria Limited versus Akinsoya, reported in 2017. And also the case of CBN versus Benin, reported in 2021, citations fully supplied. In the case of Coca-Cola Nigeria Limited, the Supreme Court on the exclusive nature and scope of jurisdiction of the National Industrial Court held, and I quote, by virtue of section 254 sub C1 of the 1999 Constitution as amended, the National Industrial Court has jurisdiction to the exclusion of any other court in civil cases and matter relating to or connected to any labor, employment, the conditions of service of labor, employee, worker, and matters incidental thereto or connected therewith. Under the subsection, The jurisdiction of the National Industrial Court covers all employment-related matters, including those arising from the private contracts of employment, and the subsection does not demarcate between private and public employment status. See the case of FCE Gusto versus Abubakar, reported in 2023. 12 Nigeria Weekly Law Reports, part 1843, page 125. Now, having found earlier that the subject matter of this suit, contrary to, is purely a labor employee matter, with the allegations of non-compliance with the conditions of service of the first defendant, it then means that this court has exclusive jurisdiction to entertain and try this matter as presently constituted. See the case of CBN versus Odo Supra, and I so hold. The claimant respondents did not join the president of the Federation as a party, which lends credence to the fact that he is not contesting or challenging the administrative decision, if any exists, but simply contesting the way and manner the employment was terminated. Given the subject matter of this suit, which, like I have said before, for the umpteenth time, is an employment matter, I am inclined to disregard and discountenance the submissions of the Learned Applicants Council on the issue of provisions of Section 251 prevailing over the provisions of Section 254C of the 1999 Constitution as amended. In addition to the submissions arising from the case of NEPA versus Idigbe Supra. This is so in the case of the latter, given that as at the time the decision in NEPA versus Idigbe was made, the amendment of the 1999 Constitution had not been effected to introduce and confer on the National Industrial Court exclusive jurisdiction in civil cases related to labor, employment, worker-employee, conditions of service, industrial relations, amongst others. The said case is therefore inapplicable and clearly distinguishable from the instant case. I am of this humble view in the light of the fact that Section 25C1 of the 1999 Constitution of the Federal Republic of Nigeria as amended confers on this court exclusive jurisdiction in civil cases where the subject matter is hinged on industrial relations, labor, employment matters, or matters incidental thereto. In the case of Maiguna versus ITF, reported in 2021, the Supreme Court had this to say on the effects of the amendment introduced by Section 251C of the 1999 Constitution as amended on the jurisdiction of the Federal High Court. And I quote, by virtue of Section 254C LA of the 1999 Constitution of the Federal Republic of Nigeria as amended, that is the Third Alteration Act, 2010, which vests exclusive jurisdiction on the National Industrial Court in respect of labor and employment-related matters. The Federal High Court was divested of jurisdiction over such matters from the 4th day of March 2011, when the alteration took effect, unquote. Our laws as they stand make provisions for a remedy where a legal injury has been established as captured in the maxim ibi remedium. As a specialized court, the National Industrial Court has exclusive jurisdiction to entertain matters bordering on complaints of legal injuries arising from employer-employee relationships, labor, workplace injuries, claims on entitlements, pensions, gratuities, amongst others. The claimant in his statement of facts has simply narrated his employment history with the first defendant when he was employed. The build-up before the letter of disengagement from service was served on him. It cannot, with respect, therefore be said that the provisions of section 251 prevails over the provisions of section 254CL. Both sections are independent of the other and confer on the Federal High Court and the National Industrial Court distinct jurisdiction, which do not always overlap. On the issue of whether this court should assume jurisdiction, it will be impinging on the rights to fair hearing of the applicant. The Apex Court has severally warned counsel to refrain from the habit of using the issue of fair hearing as a banner to call the courts to attention or as a license to coerce the court into doing their biddings. See the case of Okeke versus Uwechina, reported in 2022. Fair hearing, no doubt, is of such fundamental nature that the absence of it vitiates a proceeding. Fair hearing implies that all the parties to an action must be given equal opportunity to present their case before the court the way they know best, either in person or through counsel of their choice. See the case of LGG Limited versus Stanbic IBTC Bank PLC, number 1, reported in 2022. This court has in no way hindered the entitlement of the applicant to present his case as best it knows how, either in person or through its counsel. Fair hearing is not just a single party in litigation, but it is for all the parties. I do not think that the allegation of denial of fair hearing has any basis in this instant case. In the case of Okeke versus Uwechina Supra, the Supreme Court, Pe Abba Aji, JSC, had this to say about the conduct of parties raising the issue of denial of fair hearing as a fact said, quote, "It is not surprising that lawyers and litigants who do not usually have good cases come under the guise of to frustrate the good case of the opposing party. It is high time that if this trick is discovered, that such parties and lawyers should be visited with the hammer of punitive costs. Many appeals have lagged, lingered, or been frustrated under this particular point and bogus defense of denial of fair hearing," unquote. The instant case was instituted in the year 2012 and has lagged, owing to the issue of jurisdiction raised by the defendants, which then was overturned on appeal. The applicant has ample opportunity to raise the issue of subject matter jurisdiction, absence of reasonable cause of action, and denial of fair hearing on appeal, but elected otherwise, and is now using the instrumentality of the law and the proceedings to frustrate the progress of this case. The applicant and its counsel should know that what they sow, they will surely reap. It is just a matter of time. The applicant cannot, with deference, impute what is not stated in the claimant's pleadings as his cause of action. Consequent on this, these issues are resolved against the applicant in favor of the claimant respondents, and the applicant's submission are hereby discountenanced. Given the reasons stated above, I find and hold that the applicant's prayer number 1 fails and is hereby refused and dismissed, and I so hold. The applicant has an alternative prayer to its first relief, which borders on the course declining jurisdiction against the second applicant for failure to disclose a reasonable cause of action against him. Alternate claims are usually considered where the substantive or main claim do not succeed or is refused by the court. See the case of Nwoye versus Fan, reported in 2019, where it was held that inter alia, quote, "When a party makes a claim in the alternative, the belief is that he wants either of the relief sought, in which case when he is granted any of the reliefs, it suffices for the purpose of satisfying his claim. However, where an alternative claim is made in addition to the main claim, it is only when the main claim is refused or has not been granted that the court should consider granting the alternative claim or relief, etc., unquote. The applicant's main prayer of relief sought in his notice of preliminary objection has been refused by the court for the reason above stated. This court will thus now consider the applicant's alternative prayer or relief, which is for an order dismissing and or striking out in limine this suit as constituted against the second defendant on grounds that it does not disclose a reasonable cause of action. A reasonable cause of action simply refers to a series of facts presented before the court by a litigant that raises triable issues with chances of success. See the case of Fidelity Bank versus Massity Chemical Industries Limited and others reported in 2022. Citation supplied, where the Supreme Court had this to say, quote, the phrase reasonable cause of action means a cause of action with some chances of success when only the allegations of the statement of claim are considered. If when these allegations are examined, it is found that the cause of action is bound to fail, then the suit ought to be struck out. See the case of Babus and Co. Nigeria Limited and another versus Okafor Udeji, quoted in 2018. See also Rinco Construction Company Limited versus VP Industries Limited and another, quoted in 2005. And also Ibrahim versus Osim, reported in 1988, citations fully supplied. In determining whether or not a statement of claim discloses a reasonable cause of action, it is irrelevant to consider the weakness of the plaintiff's claim. What is important is to examine the averments in the pleadings and see if they raise some questions fit to be decided by a judge. See the case of Babus versus Co. Babus and Co. Nigeria Limited and another versus Okafor Udeji Supra, and also Dada and others versus Ogusonya and another, reported in 1992. Citation supplied. The claimant in paragraph 3 of the statement of facts made reference to the fact that the applicant is the supervisory minister in the charge of the Ministry of Aviation, which oversees the first defendant. In the light of this, the issue then is whether or not this makes the applicant a proper, desirable, or nominal party to these proceedings. One that should or may be bound by the decision of the court. In the case of Oko BMM versus UBN PLC, citations applied, was decided in 2019. It was held inter alia, quote, desirable parties are those who have interests or who may be affected by the decisions of the suit, unquote. The issue of whether a person should be joined as a party to a suit is a matter of distinction between what is desirable to do and what is necessary to do. See the case of Olawoye versus Chimo, reported in 2013. Nigeria Weekly Law Report, part 1371, page 362. The argument by the applicant that the claimant's respondent failed to respond to the issue of reasonable cause of action is a bit misplaced, as the respondent, in responding to the said issue, contended that the applicant is a necessary and desirable party to the suit, without whom the matter may not be effectually dealt with. It was therefore for the applicant to refute same on the basis that it was simply desirable for it to be joined as a party to this suit, and it was not necessary to do so. I'm of the humble view that the applicant in this instant case, given the instances of these circumstances of this suit, is a proper party who though not actually interested in the claim, is joined as a party for good reasons, which may be tied to enforcement of court orders. See the case of Chief of Army Staff versus Lawal, reported in 2012. Then Nigeria will play law report, part 1307, page 62. The claimant does have a reasonable cause of action, having set out triable issues in his pleadings before the court, and though not actually interested in the claimant's claims, has been joined for good reasons. I so find and hold. On the basis of the above, prayer 2 is hereby refused and dismissed. On the whole, the applicant's preliminary objection is hereby overruled and dismissed. The issue of determination is resolved in the affirmative in favor of the claimant respondent, and I so hold. The case is to be set down for speedy trial. Yes, and that's the ruling of the court on this. Then we have another ruling. In this case, as you well know, are we on the same page on this? We have another ruling on this. Counsel,
my lord.
Yes. Please,
Yes,
this is the second ruling. Yes. Now, this is the ruling of the court on an application dated 1st day of April 2022 and filed on the 4th day of April 2022 by the first defendant applicant seeking the following: an order of this honorable court dismissing and or striking out in limine this suit as constituted against the first defendant on ground that it discloses no reasonable cause of action. The second prayer is the omnibus prayer, and the grounds upon which the application is brought are contained on the face of the motion paper. The application is supported by a 5-paragraph affidavit deposed to by one Patrick Osisiogo, designated as a litigation officer in the law firm representing the first defendant applicants. In support of the application is a written address wherein counsel to the applicant formulated a loan issue for determination, and that is whether or not the claimant's suit discloses no reasonable cause of action against the first defendant. The learned applicant's counsel, canvassing arguments on the said issue, stated that in determining whether a suit discloses a reasonable cause of action, the court looks only at the statement of claim filed by the claimant, referring the court to the case of OHMB versus Garba, reported in 2002. Citations fully supplied. The claimant, at paragraph 10 and 23 of his pleadings, alluded that this disengagement letter was signed by the permanent secretary on behalf of the Minister of Aviation. So the claimant has no cause of action against the first defendant, and the suit should be dismissed. The claimant respondent, in opposition to the first defendant applicant's application, filed a 5-paragraph counter affidavit deposed by one Tony Egaron, a legal practitioner in the law firm representing the claimant, and a written address wherein counsel formulated an issue for determination, to which whether or not the first defendant applicant is a necessary or desirable party to this suit. Learned counsel to the claimant contended that the first defendant applicant is a necessary, that the first defendant applicant is a necessary party who has sufficient interest in this suit, without which the court cannot effectively or fairly determine the issues in question. Referring the court to the case of APC versus PDP and others, reported in 2015, citations supplied. Where one of the relief sought is likely to affect the rights of a party, such a party is considered a necessary party. Under 13 Rules 6.1 and 7 of the extant rules of this court, states so. And counsel urged the court to dismiss the application of the first defendant applicant in its entirety. The learned counsel to the first defendant applicant filed a reply on points of law with leave of court in reaction to the claimant's counter affidavit and written address, wherein counsel reiterated its submission that there is no reasonable cause of action against the applicant, and both the claimant's counter affidavit and written address did not address the issues raised in the preliminary objection, so they should be discountenanced. The first defendant applicant on the 22nd day of June 2022 filed an application brought pursuant to section 251, paragraph LPR of the 1999 Constitution as amended, seeking an order of this honorable court declining jurisdiction to entertain this suit as constituted against the first defendant. The ground upon which this application is brought are contained on the face of the motion paper, which largely is summed thus: that section 251 LPR of the 1999 Constitution gives the Federal High Court exclusive jurisdiction over any action arising from the administration and control of the federal government or any of its agencies for any action or proceedings affecting the validity of any executive, administrative action or decision of the federal government or any of its agencies. The application is supported by a 5-paragraph affidavit proposed by one Patrick Osisogwu, designated as a litigation officer in the law firm representing the applicant. In his written address, the applicant formulated one issue for determination and argued copiously that this court lacks jurisdiction, given the content of the claimant's pleadings, as his action borders on the administrative action of or decision of the federal government, which the Federal High Court has exclusive jurisdiction on. He referred the court to the case of NEPA versus Idigbe, reported in 2002. Other citations supplied. In opposition to the first defendant applicant's application of 22nd June 2022, the claimant filed a 5-paragraph counter affidavit deposited by one Mayowa Adebayo, a litigation clerk in the law firm representing the claimant. In his written address, counsel formulated an issue for determination and contended that the jurisdiction of a court is conferred on it by the Constitution and the establishing acts. A communal reading of section 254 of the 1999 Constitution as amended and section 7 of the 2006 and the pleadings of the claimant show that the claimant's case is purely a labor matter for which this court has exclusive jurisdiction. The position of the law in the case of NEPA and Idigbe Supra has been overtaken by the reenactment arising from section 254C of the 1999 Constitution as amended. The case of CBN versus Law, reported in 2020, also shows the same. Counsel urged the court to dismiss the first defendant's applicant's application in its entirety. The first defendant, in his reply on points of law, contended that paragraphs 2 to 9 of the claimant's counter affidavit contravenes section 115 of the Evidence Act as the amount to hearsay and should be struck out, referring to the case of Hake Limited and another versus Sterling Bank. Counsel contended further that section 254C of the 1999 Constitution as amended is not applicable in the instant suit, and section 251 of the 1999 Constitution of the Federal Republic of Nigeria prevails over section 254C1. citing the case of Nduba Nigeria Limited versus UBN, reported in 2009, and cases of Salami versus NJC and CBN versus Odo Supra, cited and relied upon by the claimants as distinguishable from the instant suit and are inapplicable. Assuming the jurisdiction would amount to denial, assuming jurisdiction, he said, would amount to denial of the applicant's right to fair hearing. In the court's resolution, having regards to the facts and circumstances of the suit, the processes and submissions, both in favor and in opposition to this application, the court distills the issue below for determination, and that is in the light of the claimant's pleadings and the position of the law on same, does this application have merits and is such that should be granted? It does appear that the applicant has abandoned its application filed on the 4th day of April 2022 and opted to use and rely on the application filed on the 22nd day of June 2022. The applicant had withdrawn its application titled Notice of Further Order, which was accordingly struck out. Consideration would now be made of the applicant's application of 22nd June 2022. The law is settled that the application of a court is determined by the course of action as endorsed on the writ of summons and statement of claim of the claimant. When a court has no jurisdiction, it cannot for any reason, even if it's in the interest of justice, assume jurisdiction. See the case of AC versus INEC, reported in 2007. As rightly argued by the Learned Counsel to the first defendant applicant, what determines the jurisdiction of the court is the relief sought by the claimant. Do such reliefs come within the jurisdiction of the court as adumbrated by the facts in the claimant's statement of facts and or pleadings or not? If it does not, the court must reject jurisdiction. As in every court lies an inherent power, an authority, competence, or jurisdiction to determine whether well known it lacks jurisdiction in a particular matter. I have carefully gone through paragraphs 10 and 23 of the claimant's statement of facts and observed that the claimant was just stating the obvious as regards the content of the letter dated 4th October 2021, which communicated his disengagement from the services of the first defendant. The learned applicant's counsel left or disregarded the contents of paragraphs 2, 4, 5, 6, 8, 9, 11, 13, 14, and many others that directly and indirectly alluded to facts on the action of the applicant and his agents. Counsel to the applicant must need to be reminded that as a minister in the Temple of Justice, promoting the court of justice is sacrosanct in winning a suit. I need not say more on this. This is not the stage or time to delve into the full consideration and evaluation of the claimant's case, as it would be premature to do so at this interlocutory stage. It is not for the court at this stage to determine whether the claimant has made out a case against the first defendant as to entitle it to its reliefs. The claimant in this pleading has alluded to facts linking the actions and inactions of the applicant and his agents to his complaint of unlawful termination of his employment. Parties should allow the law to have its course. Consideration of the fulcrum or basis of the claimants instituting this action would come after evidence has been adduced by the parties, and the court cannot determine one way or the other whether the claimant is entitled to the relief sought. The issue of whether or not the applicant is bound by the actions of his supervisory officials is a matter of law and facts that touch on the substance of this suit which cannot be determined at this interlocutory stage of this proceeding. I have gone through the pleadings of the claimant as contained in the statement of facts and observed that there are allusions of facts that made reference to the inactions of the applicants and its agents, thus calling on the court to look into the light of the reliefs being sought. This, in my view, makes the applicant a necessary party to this suit. A necessary party is one who should be bound by the result and the question to be settled. Therefore, there must be questions in the action which cannot be effectually and completely settled unless it is a party. See the case of NBA versus Kanyip, quoted in 2017. Citation supplied. I am in agreement with the submissions of counsel to the claimant that these proceedings may not be fairly dealt with in the absence of the first defendant applicant. It is therefore desirable and necessary to have the applicant as a party to the proceedings. I find and so hold. On the issue of the provisions of Section 251 of the 1999 Constitution of the Federal Republic of Nigeria as amended, prevailing over the provisions of Section 254C1, while the phrase, quote, notwithstanding anything to the contrary, unquote, places preeminence on the provisions of Section 251 of the matters outlined therein in conferring exclusive jurisdiction on the Federal High Court. Section 254C sub L equally has a phrase, notwithstanding the provisions of sections 251, 257, and 272, and anything contained in the Constitution, unquote, which also places precedence and preeminence of the said section over other sections in relation to matters on which exclusive jurisdiction has been conferred on it by the Constitution. In the case of Maigana versus ITF, reported in 2021, citations fully supplied, the Supreme Court had this to say on the effect of amendments introduced by Section 251C, sub 1 of the 1999 Constitution as amended on the jurisdiction of the Federal High Court. Quote, by virtue of Section 25C1A of the, are you hearing me? Of the 1999 okay, Constitution of the Federal Republic of Nigeria as amended. Third Alteration, that is the Third Alteration Act 2010, which was exclusive, which vests exclusive jurisdiction on the National Industrial Court in respect of the labor and employment-related matters. The Federal High Court was divested of jurisdiction over such matters from the 4th day of March 2011, when the alteration took effect, unquote. Once the subject matter of any dispute borders on employment, labor, industrial relation, employee, worker, conditions of service, payment of entitlement, pensions, gratuities, or matters incidental thereto, Section 251C1 of the 1999 Constitution of Nigeria confers on the National Industrial Court exclusive jurisdiction to entertain and try such matters. The claimant's case is purely an employee-employer matter with allegations of non-compliance with the conditions of service of the first defendant applicant while terminating the claimant's employment. The subject matter of the claimant's suit is not what the defendant makes it out to be, but what is contained in the claimant's pleadings. Section 254C1 is categorical in the divestment of the jurisdiction of the Federal High Court in relation to matters which subject matters border on labor, industrial relations, conditions of service, employment, and matter incidental thereto. Just as Section 4C1 of the 1999 Constitution as amended confers on the National Industrial Court exclusive jurisdiction on labor matters. Section 251 of the 1999 Constitution confers a distinct jurisdiction on the Federal High Court in relation to civil matters outlined in the subsection. The two do not overlap. The provision of Section 251 of the 1999 Constitution as amended cannot be said to prevail over that of the 254C1. The said sections are clearly distinguishable and independent of each other, I so find and hold. On the issue of the inapplicability of Section 251C, one of the 1999 Constitution as amended to the instant case, I have said earlier that the subject matter of the instant suit is labor, employment matters, which is clearly distinguishable from questioning the validity or otherwise of the decision of the federal government or any of its agencies. The first defendant does not dispute the fact that it offered employment to the claimant and that prior to the disengagement of the claimant from his services, the claimant worked in his employment. However, when it comes to the issue of the termination of the claimant's employment, the applicant raises the issue of administrative decision, a defense I am of the respectful view. It has been raised prematurely, which is akin to putting the cart before the horse, and that has created a situation of immobility to the progress of this suit. It is not the defendant's interpretation of the claimant's suit that determines the jurisdiction of the court, but the provision of the Constitution and the court's enabling acts vis-a-vis the pleadings of the claimant. The combined effect of Section 254C1 of the 1999 Constitution as amended, Section 71A, 1 and 2 of the National Industrial Court of Nigeria is that the National Industrial Court has and enjoys exclusive jurisdiction in civil cases relating to and connected to labor, employment, conditions of service, industrial relations, worker, employee, and matters incidental thereto. I am thus of the respectful view that Section 254C of the 1999 Constitution as amended is applicable to the instant suit. I so find and hold. Counsel to the applicant has argued that given the decision of the case of NEPA versus Idigbe Supra, it is the Federal High Court and not this court that has jurisdiction to entertain this suit. I'm in agreement with the submissions of the Learned Claimants Council that the position of the law in the said case has been overtaken by the amendments that introduced Section 254C of the 1999 Constitution of the Federal Republic of Nigeria as amended. As at the time the decision in NEPA versus Idigbe was made, it stood to reason that given the parties to the dispute and the provisions of Section 231 of the 1979 Constitution, the Federal High Court was an appropriate venue for ventilation of the grievances of the disputing parties. But Section 254C1 of the 1999 Constitution has conferred on the National Industrial Court exclusive jurisdiction in civil matters, of which the subject matter is connected to labor, employment, conditions of service, employer-employee relationship, industrial relations, amongst others. In that case of NEPA versus Idigbe, in my humble view, the case of NEPA versus Idigbe, in my humble view, therefore, is not applicable to the instant case. The position of the law enunciated therein in relation to the jurisdiction of the Federal High Court, having been overtaken by the enactment of the 1999 Constitution introduced by his amendment on the 4th day of March 2011. See the cases of Coca-Cola Nigeria Limited versus Akinsoya, and also CBN versus Dinne, citations fully supplied. The applicant's submission in respect of these issues are hereby discountenanced, and the issue is resolved in favor of the claimant respondent, and I so hold. The applicant's counsel has also contended that if this court proceeds to assume jurisdiction, it will be denying its fair hearing. Fair hearing is not a banner to be waved arbitrarily by litigants on their counsels or their counsels to call the court to attention. See the case of Okeke versus Uwechina, reported in 2022, citations supplied. Though so fundamental that in its absence, an entire proceedings will be declared a nullity, the applicants had failed to show how this court has prevented or hindered it from presently from presenting its case as best it knows how. Fair hearing implies that all the parties to an action must be given equal opportunity to present their cases before the court the way they know best, either in person or through a counsel of their choice. See the case of LGC Limited versus Stanbic IBTC Bank PLC, number 1, reported in 2022. This court has in no way hindered the entitlement of the applicant to present his case as best as it knows best, either in person or through its counsel. Fair hearing is not just for a single party in litigation, but for all the parties. The applicant has also been afforded equal opportunity to present its case and or defense before the court. The antecedents and antics of the applicant is what could be tantamount to abusing the process of court to frustrate the claimant by causing this case to linger unnecessarily. The applicant has ample opportunity to raise the issues it is now canvassing when it earlier raised the issue of jurisdiction that went on appeal. It also had the opportunity to raise the issue when the matter was on appeal, rather than over a decade after the matter was instituted. The applicant elects to use the machinery laid down by law as a clog in the wheel of justice, which is highly reprehensible. Given the reasons above, I find and hold that this court, assuming jurisdiction to entertain this suit, would not amount to denying the applicant fair hearing. Applicant submissions in this regard are hereby discountenanced and overruled, and I so hold. On the issue that the claimant's counsel wrongly cited the case of Salami versus NJC, as referred to portions of the said decisions incorrectly. The position of our law is well settled that counsel need exercise care in citing authorities and in reciting relevant authorities, refrain from attempting to mislead the court. See the case of Nigerian Customs Service versus Bazuaye, reported in 2006, and also the case of Idigbe versus Ibekendu, reported in 1998. While it may be noted that no human is above error, counsel has a duty to be more careful in providing all the relevant information in respect of cases he relies upon, and not to misconstrue the findings of a court. Claimant's counsel must refrain from wrong citation of cases. A word is enough for the wise. The applicant's counsel has contended that paragraph 3, sub 2 to 9 of the respondent's counter affidavit contravenes section 115L of the Evidence Act 2011, as it amounts to hearsay and should be struck out. It is the law that where a person who deposes to an affidavit is not abreast of the facts of the case, the party in whose favor the deponent deposes to the affidavit can give the necessary information or data to the authorized deponent on behalf of the party. in his action. Thank you. All the deponents in such situations would do is to show that he has consent of the party in litigation concerned and believes in the facts passed to him by the disclosed party or person. See the cases of Jemena versus Uboma and another reported in 2014, and also Lupianlong and others versus Darie and others reported in 2007. Citations fully supplied. So where a deponent to an affidavit's belief is derived from information received from another person, the name of his informant shall be stated, the reasons particulars shall be given respecting the informant and the time, place, and circumstances of the information. Yes, evidence is generally inadmissible as it has no probative value. However, hearsay is in an affidavit is admissible. Provided the source and ground of information or belief are disclosed therein. See the case of versus Oturie, reported in 2019, Sambo versus Nigerian Army Council, reported in 2017. The deponent gives information about the source of his information, the time, the place, and informant. Was information given by the deponent to the claimant's counter affidavits made to establish the truth of what was contained in the statement, or to establish by evidence not the truth of the statement, but the fact that it was made? The deposition in paragraph 3, 2 to 9 of the claimant's counter affidavits are basically a reproduction of certain portions of the claimant's statement of facts. These facts are therefore not new to either the courts or to the applicant. They are, in my view, relevant to emphasis and re-emphasizes the claimant's course of action and not necessarily made to establish the truth of his employment history. In the case of Semaila versus State, reported in 2021, the Supreme Court on the issue of admissibility of hearsay evidence held inter alia, and I quote, whether evidence of a statement, oral or written, by someone other than the witness testifying before a court is inadmissible as hearsay evidence depends on the purpose for which the evidence is given or tendered by the witness in court. In effect, the focus is on the purpose or use of the statement rather than the mere fact that it was made by a person not called as a witness. If the only relevance of the statement is the truth of its assets, it is a hearsay evidence statement. Where, however, the statement is relevant for some purpose other than the truth of their content, it is not a hearsay evidence. It is not a hearsay statement, and it is admissible in evidence, etc., unquote. So having found that the purpose behind paragraphs 3, 2 to 9 of the claimant's counter affidavit appears to be emphasizing the claimant's course of action, I find and hold that same is not hearsay. The net applicant counsel submission in this regard are hereby discountenanced. The issue thus is resolved against the defendant applicant. On the whole, the issue for determination is resolved in the negative. This court finds no merit in the first defendant applicant's application Same is accordingly overruled and dismissed, and I so hold. Case should be set down for trial, and ruling is entered accordingly. So that's it all for selected.
I'm grateful. Respectfully, I'm grateful for.
Hello? Yes?
Respectfully, my lord.
Okay. So let's take a date now. We shall take a date for trial, I guess. How do we take a date? So have you agree on a date? Or do I give you a date?
Respectfully, my lord.
Yes, yes.
My lord, I apologize that as at the time the ruling was commenced, my lord, I was still trying to sort out my Zoom, getting the Zoom, getting myself on the Zoom.
Okay.
I don't know if my lord will want to take. I greatly.
I didn't get you. Eh? Okay. Yeah, Amaka now. Yes. Okay. Let me take your appearance. Amaka.
Yes, my lord. Loretta Amaka Louis message.
Okay. Loretta Amaka. And you're for the first defendant. Okay. Defendant. Okay. We don't. Do we say? How do you stand on the 4th of July?
4th of July. 4th of July, my lord, is convenient. 4th of July is convenient.
Okay, Mr. Ige. How about you? Mr. Ige. 4th of July.
I'm sorry, my lord.
4th of July.
Lord. I'm actually my lord, I'm sorry, I'm not in this particular matter. I'm in the next one. The next matter.
Oh, okay. 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 I see. So this matter is adjourned to the 4th day of July, 2023 for trial.
As your lordship, as a court.
Yes. If there is any change, we'll let you know. Loretta. Okay.
I'm grateful.
All right. Thank you. Thank you. Okay. The court will rise for 5 minutes.
As a copy.
Mr. Again. Okay, 5 minutes.
As a copy.
All right. Is that okay here? No. I've seen it. Okay, I'm here again. We are going to take the judgment. The judgment is the one between Precious Job Egboro and the Shell Petroleum Development Company of Nigeria and SPDC West Multipurpose Cooperative Society. Mr. Ige, are you in the matter?
Yes, I'm in the matter, my lord. I'm in the matter, my lord.
Okay, please let me take your appearances.
As the copy.
Yes.
With profound respect to this honorable court.
Yes.
To Lulokwe again. I announce my humble appearance for the claimant.
Yes.
May it please the court?
Yes.
Larry Balogun for the first defendant.
Yes.
As a copy.
Is there anybody for the second defendant?
There is no appearance for the second defendant. You know.
No
okay.
No, the matter is for judgment and we are ready to proceed, subject to the convenience of the court.
Very well. Let's run through the judgment. Now, yes, this is the suit instituted by the claimants, filed a complaint in 2013. That should be 10 years ago. In an amended statement of facts dated and filed on the 31st day of May 2022, the claimant claims the following reliefs. 1, a declaration that the letter dated 30th January 2009, terminating the employment of the claimant is illegal, null and void. 2, an order directing the defendant to pay to the claimant his full salary and emoluments from the month of February 2009 till the date of judgment in this suit. Alternatively, an order directing the defendant to pay to the claimant the sum of 126,418,475 naira 35 kobo, being his unpaid terminal benefits upon terminating his employment by the defendant. Then interest on the said sum of 126,418,475 naira 32 kobo at the rate of 21% per annum from the 31st day of January 2009 until it is finally liquidated. This is the summary of the facts. According to the claimant, from his amended statement of facts dated 31st May 2022, by the letters dated 10th January 1999 and 20th January 2000, the claimant was offered employment by the defendants. The employment was confirmed via a letter dated 16th March 2001. However, arising from a fire incident that occurred during the repair of defendant's oil pipeline at Iriama in Delta State, which killed many workers working on the damaged oil pipeline, the defendant terminated the appointment of the claimant via the letter dated 30th January 2009, even though the claimant was away on official assignments in faraway Lagos. In the said letter, the defendant stated that it would forward to the claimant details of his terminal benefits. However, from that time till the time of filing the suit, no such details were forwarded to the claimant. Also, sometime in February 2009, the Department of Petroleum Resources commenced an investigation into the termination of the appointment of 7 employees of the defendants, which included the claimant. Immediately, the defendant paid the sum of 30 million naira into the account of the claimant with SPDC Waste Multipurpose Corporation Limited on the 1st of March 2009. That during the pendency of the employment of the claimant could not go on annual leave in 2005, 2006, 2007, and 2008 due to emergencies arising from pipeline vandalism caused by militants in the Niger Delta area. That the total benefits due to the claimant as at the time the defendant terminated his employment was 1,175 naira 32 kobo. The particulars were stated below as gratuity 6 million odd. B, pension funds 12,871,262 naira 51 kobo. C, redundancy package 11,482,394 naira 18 kobo. End of the year bonus 1,275 kobo, 821 naira 58 kobo. Leave allowance 5,631,212 naira 47 kobo. Payment from T&L 3 million odd. G, payment from Coke West, from Cook East, 230,000. Payment from Cook Lagos, 338,000 odd. Payment in lieu of notice, 3,827,000 naira 464, 827,464 naira 73 kobo. Then K, SVS factor, 78,657,715 naira 715 657,715 naira 31 kobo. The total sum being 126,418 naira 475 kobo 32 naira. On the part of the first defendant, from her amended statement of defense dated and filed on October 11, 2022, it stated that the claimant was employed via the letter of employment dated 10th January 2000, but erroneously dated 10th January 1999, that the reason for the termination of the employment of the claimant is not as stated by the claimant, to which the claimant connected the termination of his employment to a fire incident that occurred in the first defendant's facility in the Delta State. Rather, the reason for the termination is as stated in claimant's letter dated 30th January 2009, to the effect that the claimant's services were no longer required. That on the termination of the appointment of the claimant, he was paid the sum of 1,807,078 naira of notice. That the breakdown of the claimant's final entitlement was communicated to him in the final statement of accounts dated 20th and 28th February 2009. That the essence of claimant's final entitlement is 12,770,056 kobo, after deducting the sum of 10,653,000 896 naira 52 kobo, which represented the claimant's indebtedness to the first defendant. The balance of 2,140,229 naira 95 kobo was paid into the claimant's Group West account to partly meet his outstanding obligation to the society in accordance with the lien of form executed and whereby the defendant was under obligation to collect and remit. Furthermore, at the time of the first defendant's termination, employment of the claimant, Group West, that is the second defendant, had advised that 30 million odd was due to it on the loan facility collected by the claimant from it, that the sum of 30 million naira paid into the claimant's account by the first defendant on the 1st of March after the termination of the employment of the claimant was paid in error. On the receipt of the first defendant's amendment statement of claim of defense, the claimant filed a reply to the defense as way of rebuttal on the 3rd of November 2022. The claimant stated that the total of his 3 months' salary is not 1,807,079 naira 80 kobo as stated by the first defendant, but should be 3,827,464 naira 37 kobo at the rate of 1,275,821 naira 58 kobo per month. That is secured a loan of 14 million naira from SPDC, West Multipurpose Cooperative Society Limited. That is the second defendant on 30th of May 2007 against his monthly salary with a payback period of 11 years, that is 132 months, until his appointment was terminated in 2009. That as at the time his employment was terminated, he had already paid the sum of 3,832,402 naira 832,402 naira 40 kobo from the loan, leaving a balance of 10 million naira only. It must be noted that the second defendant, who sought to be joined as a party in this suit after the institution of this suit, filed a statement of defense and a counterclaim against the claimant, claiming the sum of 13,000 odd, being the principal sum on the mortgage loan left unpaid by the claimant. The sum of 17 million odd, representing the outstanding interest at the rate of 16% on the said principal sum, and the sum of 7 million odd, being the principal sum of the executive special loan facility left unpaid by the claimant, and the sum of 11 million odd, representing the outstanding interest at the rate of 18% on the said principal sum. However, in a term of settlement signed by the second defendant and the claimant, including the counsel, which settlement was filed on the 25th of September 2018, to which the court adopted as consent judgment at the instance of the parties. The parties, that is the second defendant and the claimant, agreed that the sum of 18,468,164 naira 47 kobo shall be paid by installments in the sum of 400,000 naira payable on or before the last day of each month. Payment was to commence on 21st day of August 2018. Hearing in this suit commenced before me on the 7th day of July 2022, to which the claimant was called to testify as CW1. He adopted his statement of oath dated 11th day of October 2022. He also relied on all the documents attached and tendered same in evidence in chief. He was subsequently cross-examined by the counsel to the first defendant. Thereafter, the claimant closed his case on the 9th of November 2022. On the part of the first defendant, he opened his defense on the 10th day of November 2022 by calling one Mrs. Uchechi Ilodianya, who adopted her witness statement on oath on the 22nd of March 2022, testified and tendered documents admitted in evidence on behalf of the first defendant. He was subsequently cross-examined by counsel to the claimant. Thereafter, the claimant closed their defense. At the close of hearing, the matter was adjourned to enable parties file, exchange, and adopt their final written addresses. In the defendant's final written address, dated 7th day of December 2022, learned counsel on behalf of the first defendant formulated 5 issues for determination. And these are: 1, whether the claimant's employment to the first defendant was properly terminated. 2, whether the various loans and advance lump sums received by the claimant was fully paid up and justifiably deducted from the claimant's final entitlement, whether recovery on behalf of the second defendant was justifiable. 3, whether the first defendant correctly calculated the claimant's final terminal entitlement of benefits. 4, whether the claimant is entitled to leave buyout. And 5, whether the claimant proved his case by credible evidence to justify his claim. On issue number 1, that is whether the claimant's employment with the first defendant was properly terminated, learned counsel to the first defendant submitted that contract of service is the foundation on which the aggrieved employee must found his case. That in the case hearing, the claimant was employed by the letter dated 20th January 2000, which was tendered as Exhibit C2, that the termination of the employment of the claimant was done in compliance with Exhibit C2, which is the employment letter to the claimant. Therefore, the employment of the claimant was properly terminated. On issue number 2, that is whether the various loans and advance lump sum received by the claimant fully paid up and justifiably deducted from the claimant's final entitlement, and recovery on behalf of the second defendant was justifiable. Learned counsel to the first defendant submitted that it is clear from the claimant's testimony under cross-examination that he intends to mislead the court. That in claimant's testimony during cross-examination, he did not deny receiving loans and allowances from the first defendant, but denied his indebtedness. That it is the duty of the claimant to prove that he has repaid all the loans collected from the first defendant. As such, since the claimant did not testify orally or present documentary evidence in support of paragraph 3.1 of his reply to the defendant's statement of defense, that is not indebted to the first defendant, he is deemed to have abandoned his pleadings. He urged the court to rely on the case of Uwegba and A.G. Vendel States, reported in 1989, one Nigeria Weekly Law Report, part 16, page 303. That since the loans, advances, and lump sum payments were loans to the claimant, the first defendant naturally will be at liberty to set off same from the claimant's entitlement upon cessation of his employment with the first defendant. That a total of 10 million odd was given to the claimant as advances, loans, and other benefits paid in advance and not fully earned by the claimant. On whether the first claimant can recover the debt on behalf of the second defendant, that is the Cope West, Learned Counsel to the first defendant submitted that Exhibit D6, which is a copy of the memorandum of, which is a copy of the memoranda of understanding executed between the first defendant and the second defendant, especially clause 1.5, gives the first defendant such power, and claimant being aware of his indebtedness, his consent is dispensed with. On issue number 3, that is whether the first defendant correctly calculated the claimant's final terminal entitlements of benefits, Learned Counsel to the first defendant submitted that in paragraph 21 of the claimant's statement of facts, the claimant stated that the total benefits due him as at the time of his employment was terminated is 126 million odd, without stating how he arrived at the figure. It is the submission of Learned Counsel to the first defendant that claimant has failed to lead credible evidence on how he arrived at the figure claimed as the total of his terminal benefits. That claimant having failed in his duty, the court should admit the credible evidence proffered by the defendant in rebutting the mere assertion of the claimant. He referred the court to the case of Alachenu versus Osheke, reported in 2002, 9 Nigeria Weekly Law Report, part 773, page 521. On issue number 4, that is whether the claimant is entitled to leave buyout, Learned Counsel to the first defendant submitted that clause 9.14.2 of the personnel policies and procedure manuals, that is Exhibit D14, is the relevant document to be considered. That it is stated therein that leave should be taken in the calendar year it is due and should not be accumulated. That in very special circumstances, a maximum of 10 working days leave may be accumulated in 1 year and carried forward to the following year. That under the clause, leave applications must be approved by the functional manager and must be used up when the next leave is taken. That the claimant in the case hearing, despite saying that he is owed 61 days leave, he has been unable to prove how he arrived at the 61 days. Furthermore, under clause 9.14.4 of the personnel policies and procedure manual, the general rule on this is that there should be no cases of leave buyout, as staff will be expected to clear all their leave every year and may only carry over not more than 10 days leave, and leave not taken during the previous year beyond 10 days will be forfeited. However, in exceptional cases where work makes requirements impossible for employers to either take their leave or carry forward their accumulated leaves, the leave buyout application must be supported by the line manager and director, and it must be approved by the human resource director. That in the case hearing, the claimant did not seek necessary approval. As such, he cannot be entitled to leave buyout. On issue number 5, that is whether the claimant proved his case by credible evidence to justify his claim. Learned Counsel to the first defendant submitted that the claimant is not entitled to any of the relief sought, as he was unable to prove same through credible evidence. He therefore urged the court to dismiss the claim with substantial costs. On the part of the claimant, on receipt of the first defendant's final written address, he filed his final written address through his lawyer on 31st January 2003, to which he formulated a sole issue for determination, and that is whether or not the claimant is entitled to the relief sought. Learned Counsel to the claimant submitted that the contract of employment between the claimant and the defendant is governed by Exhibit C1, C2, and C10. Exhibit C1 is a letter of employment dated 10th January 1999. Exhibit C2 is the contract of service dated 20th January 2000. And Exhibit C10 is the defendant's human resources policy. That whereas Exhibit C2 provides that either of the parties can terminate the employment, the procedure for termination of employment can be found in sections 1.8, 2.3, and 2.4 of Exhibit C10. That termination, according to Exhibit C10, can either be initiated by the company, that is redundancy or dismissal, or the employee, that is by resignation, in accordance with the appropriate clause in the individual's contract of service. That in Exhibit 1.8 it provides thus termination by the company with notice, normal termination in accordance with the appropriate clause in the individual's contract of service. In such cases, the employee will be given as much advance warning as the circumstances permit. The Learned Counsel to the claimant submitted that with the above provision, no employee of the defendant can be disengaged without advance warning, inclusive of the claimant. Furthermore, under section 2.32, it is provided that no disciplinary action should be taken against an employee without an investigation to establish the facts, in the course of which, one, the employee should always be given the opportunity to state his or her case. Two, the employee should always be informed of the outcome of such investigation and of any decision to take disciplinary action. Except for verbal warnings, this advice should be given to him or her in writing. That in the case herein, the defendant did not carry out the provisions of the section above, as there was no investigation carried out to establish the facts. Neither was the claimant given an opportunity to state his case or informed of any of the outcome of any investigation. Then counsel to the claimant submitted further that there are circumstances where dismissal with notice of salary in lieu of notice may be considered appropriate. For example, where dismissal is proposed as a final step in a chain of disciplinary actions arising from consistently unsatisfactory behavior, poor performance, or misconduct. That since the termination of the employment of the claimant was at the instance of the defendant, it was a dismissal, and given the relevant provisions of SBC 10, the said dismissal was not done according to the procedure laid down therein. On the alternative claim of the claimant, Learned Counsel to the claimant submitted that the guiding principle of alternative relief is as stated in MV Caroline Maersk, sister vessel to MV Christian Maersk versus Nokoi Investments Limited, reported in 2002. The citation was fully supplied, where it was said, and I quote, where a plaintiff sets two or more inconsistent sets of material facts and claims relief on each of them in the alternative, he will be granted such relief as the set of facts he established would entitle him. Only one of two or more alternative reliefs will be granted, etc., unquote. Learned Counsel submitted that in the case herein, the court has the prerogative of deciding which of the alternative reliefs the claimant is entitled to. That the claimant averred that defendant did not communicate or pay him his terminal benefits. The defendant, on the other hand, averred that she duly communicated the breakdown of the claimant's final entitlement to him. The defendant tendered an unsigned letter dated 27 January 2011, sent to one Mr. Otu Iwang. The position of the law is that it's clear on this. In the case of global soap and detergents Industries Limited versus NAFDAC, reported in 2011. The court held, and I quote, "It is trite that on an unsigned and undated document is a worthless piece of paper that has no evidential value in law," unquote. Counsel therefore urged the court to discountenance the letter dated 27 January 2011. On claim number 3, legal counsel to the claimant submitted that the claimant's claim for interest is at the discretion of the court, especially where interest is not the contract of the parties. However, he urged the court to consider the valuation of Naira in the award of interest. He also urged the court to apply international best practice in labor and industrial relations. It is the submission of legal counsel to the claimant that the claimant has proved his case on the balance of probability and urged the court to grant the relief sought by him, the claimant. On receipt of the final written address of the claimant, the first defendant filed a reply on points of law dated 14 February 2023, to which he replied and adumbrated on points of law to claimant's final written address. This is where the matter was handled. Having gone through the claimant's claim, the evidence led in support, the defendant's defense, evidence led in support, and the final written submissions of both counsel to the parties, this court, while adopting the issues formulated by legal counsel, has distilled the sole issue for determination, and that is to say, whether the claimant has proved his case to be entitled to the relief sought. Generally, civil cases are won on the pleadings and evidence led in support of the pleadings. When a matter borders on special damages, the trial law is, unless pleaded and strictly proved, the court is not obliged to make any award on special damages. See the case of IHAB UHMB versus Kanyip, reported in 2011. 12 Nigeria Weekly Law Report, part 1260, page 1. The most important ingredient for winning a civil case are the pleadings and evidence led in support of the pleadings. A loser in a civil case loses because of how porous his pleadings are and how watery the evidence in support of his pleadings is. Furthermore, parties are bound by their pleadings. Therefore, whatever was not pleaded cannot be relied upon, nor can a written address be used to fill any lacuna or a fact that was not pleaded. This is so because the trial law is that no matter how beautiful a written address is, it cannot substitute pleadings. It cannot be tantamount to pleadings, and it cannot be used to give evidence. Furthermore, facts admitted need no proof. I say this since some of the facts in the case herein need no further proof, on the ground that parties in this suit admitted to same. In this vein, such facts shall be considered relevant to the extent to which the parties admitted to them. The first relief sought by the claimant is to declare the termination of the employment null and void. According to the claimant, he was not given any warning, nor was the allegation against him investigated. He referred to various sections of the defendant's personal policies and procedures, which was tendered and admitted by this honorable court in evidence. I have gone through the said personnel policies and procedure handbook, and when juxtaposed with the position of the claimant, I can see two things. It is either the claimant does not fully understand the contents of Exhibit C10, or he's just exaggerating some in his favor. Be it as it may, the role of the court is to interpret. And if the court is faced with what is referred to as in medical circles as Munchausen syndrome, a situation where one exaggerates his condition to attract sympathy, The court will be quick to remind herself that a court of law is not a place of emotions and sentiments, but a place of law and justice. And the doing of this justice relies on cold facts and evidence. Before commenting further on the provision of Exhibit C10, which is the defendant's personal policies and procedure handbook, I would like to state that there are certain ingredients that the claimant who complains that his employment was wrongly terminated has to prove. These are stated in NIMSA versus Obe, reported in 2014. Citation supplied, where the court held thus, quotes, a claimant who seeks a declaration that his employment has been wrongfully terminated must prove the following material facts, namely, A, that is an employee to the defendant, B, terms and conditions of his employment, and C, the way and manner and by whom he can be removed. It is not the principle for the employer who is a defendant to an action brought by the employee to prove any of this. The claimant in the case hearing has shown his employment relationship with the defendant by his employment letter, which is in evidence before this honorable court. He has also shown the terms and conditions of his employment as part of what is stated in his employment letter and the defendant's personal policies and procedure handbook, which is in evidence before this honorable court. He is challenging that the way and manner he was removed contradicts the provisions of the defendant's personal policies and procedures handbook. Now, starting with the claimant's employment letter, in Exhibit C2, which is dated 20th January 2009 and titled Contract of Service, Shell Nigerian, in paragraph 10, it is stated thus, and I quote it, paragraph 10, you or the company shall have the right at any time to terminate your employment under this letter by giving to the other not less than 1 month's notice in writing, or by paying 1 month's salary in lieu of notice. On confirmation of your appointment, the period of notice shall be 2 months, or 2 months' salary in lieu of notice. And on the completion of 5 years of service, the period of notice shall be 3 months, or 3 months' salary in lieu of notice. Unquote. Employment of the claimant in this case was not only confirmed, but he worked for more than 5 years with the defendant. In this light, the period of salary or period of such notice is 3 months. This position was re-echoed in section 181.1 of the Personal Policies and Procedures Handbook, tendered in evidence as Exhibit C10. I would like to reproduce the provision of Exhibit 1.8 to 1.811 of the said handbook. It provides thus, quote, termination of employment can either be initiated by the company, that is redundancy or dismissal, or the employee by resignation, in accordance with the appropriate clause in the individual contract of service. On resignation, I quote, this is termination of employment at the initiative of the employee concerned. The employee should submit in writing his or her resignation to his or her team leader, who should immediately consult with the HR business partner. In all cases of resignation, the functional or line manager and the director or GM should be informed. A decision is then taken on whether to accept or reject the resignation before it is forwarded to the team HR unit for action. The HR business partner then arranges the documents and exit interview with the staff in question. A letter specifying the separation terms should then be prepared by the HR business or welfare service unit for the signature of the team leader. Thereafter, the letter passes on to the team leader for delivery to the employee, unquote. 1.811 says, confirmed members of staff who have served less than 5 years must give the company not less than 2 months notice or 2 months pay in lieu of notice. Staff who have served 5 years or more must give the company not less than 3 months notice or 3 months pay in lieu of notice, unquote. Now, what is stated above is not different from what is stated in the claimant's employment letter. I see no ambiguity there. There is nothing there to cause confusion in the mind of the claimant. From the above, it is clear that either party can bring the employment relationship to an end. And when this happens, either party is to give notice or pay salary in lieu of notice, taking into consideration the number of years the employer has worked in the company. It is not the duty of the court to rewrite agreements for parties. The contract of service in this case was entered by the claimant and the first defendant. And if the first defendant decides to exercise his rights as granted by the contract, it cannot befall on the court to indict the first defendant or change the agreement freely entered by the claimant and the first defendant. Furthermore, in section 1.82 of the Personnel Policy and Procedure Handbook, which the claimant relies on, it provides thus, quote, termination by the company without notice only in cases of serious offenses as explained in the contract of service. See dismissal section 2. B, with notice, normal termination in accordance with the appropriate clause in the individual's contract of service. In such cases, the employee will be given as much advance warning as circumstances permit. See section 2.3 on dismissal with notice. As can be seen above, the whole gamut of section 1.2 deals with dismissal. There are legal implications when an employee's appointment was terminated and when the employee was dismissed from office. An employee that is dismissed from office will not be entitled to any terminal benefits or final benefits arising from the employment. Therefore, it is not even advisable for an employee who is claiming an amount in the sum of 126 million odd to argue with every fiber in his being that whatever happened is dismissal and not termination. He will end up not only shooting himself on the foot, but losing all entitlements he thinks he's entitled to. Be it as it may, the court, having looked at the facts and evidence in this case, is satisfied that the employment of the claimant was brought to an end by way of termination and not dismissal. As such, it is section 1.8, 1.81 and 1.81.1 of the Personnel Policies and Procedures Handbook that apply to the circumstances of this case. Section 1.82, which deals with circumstances of dismissal, is not applicable to this case, and I so hold. Furthermore, section 2.3 of the Defendant's Personnel Policies and Procedure Handbook, which deal with disciplinary procedure, is not applicable to the case of the claimant because even though such disciplinary measures may lead to dismissal, by the very spirit of the section, disciplinary actions are not dismissal or termination, but actions to make employees aware of behaviors and or performance which a company considers unacceptable, and to indicate corrective actions which must be taken if the employee is to remain in the company's employment. See section 2.3a. Much so, having found earlier that the case of the claimant was termination exercised by the defendant as a right arising from the employment contract, and given that from the face of the termination letter, there is nothing there to suggest that it was a disciplinary action against the claimant. The court is bound to hold that section 2.3 is not applicable to the case of the claimant. Therefore, if there is anything wrong with the termination of the employment of the claimant, it is in whether 3 months notice was given or 3 months salary was paid in lieu of notice, in line with the terms and conditions of the employment of the claimant. The claimant is also entitled to his end terminal benefits. See the case of Maja versus Troko, reported in 1968, and UBN versus Suarez, reported in 2012, the citations supplied. That said, the court cannot and will not declare the letter dated 30th January 2009, terminating the employment of the claimant illegal, null and void, and I so hold. Claim one of the claimants is bound to fail. The court, having determined that the termination of the claimant's employment is a right derived from the employment contract, cannot order the defendant to continue paying the claimant his full salary and emolument from February 2009 till date, as if the employment relationship between the parties still subsists. In the case herein, the claimant's calculation of his 3-month salary is 3,827,464 naira 73 kobo, at a salary of 1,275,821 naira 58 kobo per month. On the part of the defendant, the claimant's 3-month salary is 1,807,079 naira 80 kobo. Being as it may, the dispute here is not whether the claimant is entitled to 3-month salary in lieu of notice, but it is a dispute on the correct amount claimant is entitled to as 3-month salary in lieu of notice. In the claimant's final written address, claimant alluded to Exhibit D5. Are you hearing me now? Okay. So can they hear me now? Hello? Okay. Claimant, okay. He posited that the best slip. Now let me take it from where it will make some sense. In the case herein, the claimant's calculation of his 3-month salary is 3,827,464 naira 73 kobo, at a salary of 1,275,821 naira 58 kobo per month. On the part of the first defendant, the claimant's 3-month salary is 1,807,079 naira 80 kobo. Being that as it may, the dispute here is not whether the claimant is entitled to 3-month salary in lieu of notice, but it is a dispute on the correct amount the claimant is entitled as 3-month salary in lieu of notice. In the claimant's final written address, the claimant alluded to Exhibit D5, that is his payslip, tendered by the first defendant. He posited that the payslip for December 2009 shows that the claimant's taxable gross pay was 17,876,733 naira 47 kobo. If this is divided by 12 months, it will amount to 1,489,729 naira 45 kobo. When that sum is multiplied by 3 months, the result is 4,469,188 naira 38 kobo. Well, In the defendant's letter terminating the employment of the claimant, that is as we see 9, the second paragraph states thus: please contact the HR service desk to collect a check for 3 months basic salary in lieu of notice, in lieu of contractual notice. Now, this court takes judicial notice of the fact that most of these contracts are adhesion contracts. That is, contracts where one of the parties has a significant degree of control over the parameters of the arrangement, more of a standard contract to which the other party is not given the opportunity to negotiate the contract, but to append his signature. When faced with a situation of contract of adhesion, any ambiguity is resolved against the party with significant control over the contract. In the light of this court will take note that the claimant's employment letter, there is no way it is stated that 3 months salary in lieu of notice shall be 3 months basic salary. As such, it is not open to the defendant to pay the claimant 3 months basic salary, that is net of tax, as salary, and I so hold. Given this, the claimant shall be entitled to 3 months salary in lieu of notice, as reflected in his last or most recent payslip. The claimant stated that the total of his 3 months salary is not 1,807,079 naira 80 kobo as stated by the first defendant, but should be 3,827,464 naira 36 kobo at the rate of 1,275,821 naira 58 kobo per month. Among the payslips tendered by the defendant is the one of January 2009. In the payslip, the claimant's payment is tabulated as follows: basic salary 752,949.50 kobo. 2, power improvement, always whatever, 76,800 naira. Fuel allowance 23,094 naira. Status car allowance 75,783 naira 58 kobo. Market comparison 15,166 naira 67 kobo. Housing income supplement 128,291 naira 33 kobo. HIG grants 13,592 naira 15 kobo. HIS lump sum 1,231,596 naira 80 kobo. HIG lump sum 652,423 naira 20 kobo. PIA lump sum advance 737,280,000. CHIP grant 39,537 naira 57 kobo. CHIP grant tax 9,884,039 kobo. HIG grant tax 3,598 naira 4 kobo. Car grant 47,560 naira 67 kobo. Car grant tax 11,850 naira 17 kobo. Meal reimbursement 23,436 naira only. From the above, apart from items 7 to 16, which cover grants, lump sum, advance, tax, etc., items 1 to 6 are constant in the payslip of the claimant from September 2008 to January 2009, when the employment of the claimant was terminated. If the item in 1 to 6 are all added up, the amount will be 1,000. The amount will be 1,072 naira 85 1,072,085 naira 8 kobo. If this amount is multiplied by 3, that is 3 months, the total will be 3,216,255 naira 24 kobo. It is this sum that the claimant can be entitled to as 3 months' salary in lieu of notice. On the 3rd and 4th reliefs sought by the claimant, which are alternative reliefs, the claimant seeks the sum of 126 million odd as his unpaid terminal benefits upon the termination of his employment and interest in the same sum, respectively. How did the claimant arrive at this sum? According to the claimant, he worked for 9 years with the first defendant. His gratuity ought to be 4% of his annual pensionable salary multiplied by the number of years he worked. That his annual pensionable salary at the time of his employment came to an end was 17,876,753 naira 50 kobo. The 4% of 17,876,753 naira 50 kobo is 715,070 naira 14 kobo. If this sum is multiplied by 9 years of service, claimant's gratuity will be 6,435 kobo, 1,631 naira 25 kobo. The defendant in paragraph 30 of her statement of defense agreed with the calculation of 4,000 of claimant's annual salary and multiplying the said sum of 4% by 9 years of service. However, the defendant based her own calculation on an annual sum of 9,788,343 naira 50 kobo and arrived at 3,508,525 naira 33 kobo as claimant's gratuity. 4% of that sum is 391,533 naira 74 kobo. By multiplying 391,533 naira 94 kobo by 9 years, that is the 9 years the claimant worked, the defendant arrived at 3,523 naira 803. 530, 23,803 naira 33 kobo. What then is the annual salary of the claimant? Now, the court has earlier found that the monthly salary of the claimant is 1,072,085 naira 8 kobo. The court arrived at this amount based on the pay slips tendered in evidence before this honorable court. In arriving at this amount, the court had to look at the recent pay slips starting from September 2008 to January 2009, when the employment of the claimant was brought to an end. The court had to separate the items listed as basic pay, power improvement allowance, fuel allowance, status and car allowance, market comparison, housing income supplement from others listed as HIG grants, HIS lump sum, HIG lump sum advance, cheap grant tax, HIG grant tax, car grant tax, etc. This is so because from what the name suggests, those are grants, advance payments, etc., made to the claimant by the defendant. They cannot qualify as money earned as salary. Furthermore, if they serve other purposes more than what is stated, the claimant failed to explain to the court what that purpose is, leaving the court to speculation. Now, the trial law is that it is not open to the court to speculate. Having failed to explain to the court on the purpose of monies listed in items 7 to 16, the court can only give the ordinary meaning to those items. Now, being that the claimant's monthly salary is found by the court to be 1,072,085 naira 8 kobo, if the said sum is multiplied by 12 months, which make 1 year, the annual salary of the claimant will be 12,865,020 naira 96 kobo. Now, 4% of this sum is 514,600 naira 83 kobo. If that amount is multiplied by the 9 years of service, the answer will be 4,631,407 naira 47 kobo. It is this amount that the claimant is entitled as gratuity. For the claimant's pension lump sum, the claimant claims that it is 8% of 16,885,680 naira 48 kobo multiplied by 9 years, which equals 6,435,631 naira 25 kobo. On the part of the defendant, her position is that what the claimant is entitled to pension lump sum is 8% of 9,788,343 naira 80 kobo multiplied by 9 years, which equals to 7,077,000 and then 515 naira. Now, since the salary of the claimant is a cause of variation in the calculation of the claimant and the defendant, and since the court has already found out that the claimant's annual salary is 12 million odd, the court will use this sum in the calculation of the pension lump sum the claimant is entitled to. In this vein, 8% of 12 million odd is 1,029,201 naira 67 kobo. If this amount is multiplied by 9 years of service, the answer is 9,262,815 naira 3 kobo. By extension, what the claimant is entitled to as pension is a pension lump sum is 9,262,515 naira 3 kobo. On the claim on redundancy, this court wishes to state that the termination of the claimant's employment has no link or relationship with employment brought to an end by way of redundancy. As such, laying claim to redundancy is tantamount to a farmer reaping where he did not sow. That said, the court finds and holds that the claim on redundancy cannot avail the claimant. On leave allowance and leave allowance buyout, the claimant was unable to prove to the satisfaction of this court on his claim on his claim on this head. As such, the court cannot grant this on want of evidence. On the end of year bonus, the claimant cannot be paid the end of year bonus twice. It is glaring from Exhibit D11 that the claimant was paid his year bonus for the year ending December 2008. On payments from thrift and loans, claimant is entitled to the sum of 3,696,539 naira 84 kobo. He is entitled to all his personal contributions to the Cooperative West, Cooperative East, Cooperative Lagos States in the sum of 1,329,859 naira 35 kobo. Then 230,000 naira and 338,855 naira 45 kobo, respectively. He's also entitled to the sum of 3,216,255 naira 25 kobo, being 3 months' salary in lieu of notice. As to the SVS account amount, the correct calculation is 12,865,020 naira 96 kobo multiplied by 22, which equals 283,030,461 naira 12 kobo. 20% of the said sum is 56,606,092 naira 24 kobo. As such, what the claimant is entitled to as SVS is 56,606,092 naira 24 kobo. The first defendant's position is that the claimant is not entitled to this sum, being that it was not a voluntary retirement. However, this court wishes to state that since the claimant still had 22 years before his retirement, and since the defendant brought his employment to an end before the retirement age, and since the defendant has in his policy to pay the differential of the remaining years through percentage, the claimant is entitled to benefit from the same, and I so hold. From all the above, the entitlement of the claimant is tabulated as follows. I may not go through the kobos and the nairas. One, the gratuity is 4.6% odd. That is 4,631,407 naira 47 kobo. Two, pension fund, 9,262,815 naira 3 kobo. Three, payment from T&L, 3,369,536 naira 84 kobo. Four, payment from Coop West, 1,329,857 1,329,857 naira 35 kobo. Payment from Coop East, 230,000 only. Payment from Coop Lagos, 333,855 naira 48 kobo. Payment in lieu of notice, 3,216,255 naira. Then SVS factor, 56,606 naira, 92 kobo, 24 naira. The total is 97,584 naira, 819,038 kobo. As for the money owed the defendants by the claimant, the first defendant in paragraph 16 of her statement of defense stated thus, quote, the defendant will also prove that the claimant was, prior to his disengagement, indebted to it in the sum of 653,896 naira 52 kobo for various and sundry advances, loans, and other material benefits, particularly by way of housing income, supplements, home improvement grants, power improvement allowance, cheap lump sum payment, and the car grants, all of which have been paid in advance to the claimant, but has not been fully earned by the claimant and or amortized by the defendant over the required period of time. And such annual payments were made to the claimant as follows. Cheap lump sum in the sum of 5 million odd paid to the claimant via pay slip. They show the pay slip. The second one is the car grant lump sum in the sum of 2 million odd, with outstanding sum of 2,140,229.95 yet to be recovered. And then 3, HIS lump sum advance in the sum of 1,231,596 naira 80 kobo. 4, PIA lump sum advance of 737,280 naira. 5, HIG lump sum advance in the sum of 652,423 naira 20 kobo. The defendant yet to be recovered as evidenced in January 2009 payslip. Then 17, he said the defendant will further prove that the claimant, in the course of his employment with the defendant, took a loan facility from SPDC, West Multipurpose Cooperative Bank, that is Group West, for which the claimant had placed a lien on his final entitlement from the defendant as a collateral. At the time of the defendant's termination of the claimant's employment, Group West had advised that 30,603,909 naira 94 kobo was outstanding and due to it on the loan facility. In reaction to the vehemence of the first defendant, as stated, the claimant in paragraph 4 of his reply to the defendant's statement of defense stated thus: in reply to paragraph 16 of the amended statement of defense, the claimant says that 1, he is not indebted to the defendant for any cheap lump sum in the sum of 5,620,418 naira 10 kobo. 2, that is not indebted to the defendant for any car grant lump sum. 3, that is not indebted to the defendant for his lump sum advance in the sum of 1 million odd. And 4, that is not indebted to the defendant for any PIA lump sum advance. And 5, that is not indebted to the defendant for any high HIG lump sum in the sum of 652,423 naira. First of all, this court wishes to state that paragraph 17 of this defendant's statement of defense has been overtaken by events. As such, it is of no moment. This is so because whatever the claimant owes or owed the SPDC West Multipurpose Cooperative Society, the second defendant in this suit, has been settled by virtue of the terms of settlement filed before this honorable court on the 25th September 2018, which was adopted the same day as consent judgment between the claimant and the second defendant, that is the SPDC West Multipurpose Cooperative Society. In this light, any lien placed on the account of the claimant for the purpose of offsetting what he owes or did not owe the second defendant is null, void, and of no consequence. With regards to paragraph 16 of the defendant's statement of defense, to which the claimant responded that he owes the defendant nothing, I must say that the facts and evidence of this case speak for themselves. From Exhibit D5 to D11, which are a claimant's payslip tendered before this honorable court, are grants, loans, and advances to the claimant, which are codenamed HIS, HIG, PIA, etc. All these codes will not make sense at first sight until one is made to understand that HIS stands for Housing Income Supplement, HIG for Home Improvement Grant, PIA is Power Improvement Allowance. Be it as it may, the court will like to reiterate that money collected as grants, loans, or advances cannot translate to money earned. In this vein, claimant is liable to pay back to the first defendant what was paid to him as loans, grants, and advances, and I so hold. From the evidence before the court, grants, loans, and advances payments were made to the claimant, to which the claimant was unable to prove that he has fully paid back such monies. In the circumstances, the claimant is liable to pay back the sum of 10 million odd to the defendant, and the defendant can exercise her power of lien on the said sum if at the time of the termination of the employment of the claimant was yet to pay the sum in full to the first defendant. From all that have been said above, the case of the claimant succeeds as follows. The first one fails, the first claim fails, the second claim fails. Claim 3, being alternative relief, succeeds to the extent that the first defendant shall pay the claimant the sum of 79 million odd, less 10 million odd, being the sum claimant owes the first defendant, as claimant's unpaid terminal benefits upon the termination of his employment by the defendant. Claim 4, being an alternative relief, fails for given the circumstances of this case, the court cannot be moved to grant any sum as interest. For the avoidance of doubt, the orders and declaration of the court are as follows. The court hereby orders the first defendant to pay the claimant the sum of 79,884,819 naira 38 kobo, less 10,653,896 naira 52 kobo, being the sum claimant owes the first defendant, as claimant's unpaid terminal benefits upon the termination of his employment by the first defendant. And this is the end of the judgment, and judgment is entered accordingly.
As the court please.
As the court please, you're most grateful.
We are most grateful for a well-considered judgment.
Thank you very much.
The time and your patience. Thank you, my Lord.
Thank you.
Thank you, my Lord.
Very well. Very well. Thank you.
Hello? My Lord, I hope we can get a copy of
You mean a copy of this?
Yes, my Lord.
Yes,
The copy of the judgment.
the court will try to edit it, cross the T's and dot the I's as soon as possible. As soon as possible. You know, there are so many of these judgments, so please, you just give a little while. You will get it. Maybe by the end of next week.
Okay, as the copy.
Thank you. Thank you.
Your Friday, which is in Sunday, the Thursday. Which is 50. Alright.
When I was writing the other one was putting the Hello, Council. So Lula still here. That's right. Okay. Please let me know who is for LA 76 2017. Vincent Okocha. And okay. And Salus Trust Fund. Are both of you here?
Yes, my lord.
Okay.
My lord.
Yes.
Salus Trust is here. I've been here since 11 a.m.
Hey, sorry. Well, anyway, we had this is not the only judgment. I'm very sorry.
Yes, I've been
we had
following. I've been
judgment and
following. No problem.
okay, let me take your appearances, please. Appearances?
For the claimant,
yes.
Vincent Okocha.
Are you appearing in person?
No, I'm at, respectfully, my lord.
Yes.
Kelechi Njaka is my name. Njaka is spelled N-J-A-K-A.
Okay.
And my home appearance for the defendants.
Okay. Yes. Yes, who is on the other side?
Vincent Okocha.
Okay. Vincent Okocha is a claimant. Yeah. Are you appearing for yourself?
I'm appearing for myself today.
Okay.
Yeah. Sorry, my lord, I'm not robed.
Okay. Well, it doesn't matter. It's just, it's just a ruling. So it's just to read it out. Yes. So there are two rulings actually, but two short rulings. I'm going to run through them. So the first one is this. The first one is the ruling of the courts on an application brought by the defendant applicants, dated and filed on the 16th day of June 2022, brought pursuant to relevant rules of the court and the laws of Nigeria, and under the inherent jurisdiction of the court, praying for the following. A, an order of this honorable court striking out the third amended statement of facts, dated 15th August 2019, for being incompetent as it offends the provisions of rules of this honorable court. The second is, that is the last prayer, is the omnibus prayer. The ground for the application is as contained on the face of the motion paper. The application is supported by a 7-paragraph affidavit deposed by one Esther Waifo, designated as a litigation officer in the law firm representing the applicant. In their written address, counsel to the defendant applicant formulated an issue for determination, and that is whether the third amended statement of facts dated 15th August 2019 is liable to be struck out for being incompetent. Canvassing arguments on the said issue, Leonard Silk, counsel to the applicant, submitted that by virtue of Order 26, Rule 6, and Order 57, Rule 4 of the National Industrial Court Rules, a party who has obtained an order to amend must do so within time, and when such a person is out of time, the proper thing to do is to ask for extension of time to comply with the orders for which he is out of time. The claimant had 7 days to amend his pleadings, and the pleadings were never amended until the 15th day of August 2019. The claimant never applied to extend the time to file his pleadings out of time. And as such, this makes the pleading incompetent and liable to be struck out. It referred the court to Kanyip versus Yazid, reported in 2001, 17 Nigeria Weekly Law Report, part 742, page 88. And also the case of Oyo versus Akinyemi, reported in 2008, 15 Nigeria Weekly Law Report, part 1109, page 21 and 48. Counsel then urged the court to strike out the third amended statement of facts dated 15th of August 2019. In opposition to the application, the claimant filed a 14-paragraph counter affidavit deposed by one Samuel Owaje, a litigation assistant in the law firm representing the claimant respondent. In his written address, the claimant formulated 2 issues for determination. And these are: 1, whether the defendant's motion or notice dated 16/6/2022 is incompetent and ought to be struck out. And 2, Does the defendant's motion on notice dated 16/6/2022 constitute an abuse of court process to warrant dismissal and award of punitive costs against the defendant and their counsel? On the first issue, learned counsel to the claimant submitted that the defendant's motion on notice dated 16/6/22 to strike out the third amended statement of facts dated 15/8/2019 is incompetent for reckless disregard of rules of court and not to be struck out, as this court is empowered to strike out any application not permitted by the rules of court. Referred to Order 30, Rule 18, Sub 1 of the Instant Rules of this court, 2017. The defendant failed to comply with Order 15, Rule 11 of the National Industrial Court, Civil Procedure Rule 2017, and an application brought without complying with the rules of court is incompetent. It referred to the case of Ogunpehi versus Nucleus Venture, 2019, and also Dada versus Dosumu, reported in 2006, both citations fully supplied. On the second issue, learned counsel submitted that this application by the defendant applicant is an improper use of judicial process to interfere with the due administration of justice and to the annoyance and irritation of the claimant, and therefore constitutes a gross abuse of court process, referring to the case of Saraki versus Kotoye, reported in 1992, 9 Nigeria Weekly Law Report, part 264, page 156 at 188. In the circumstances, counsel urged the court to impose a punitive cost of 10 million naira only against the defendant applicants and their counsel payable to the claimant respondents. On receipt of the claimant's response, in opposition to his application, the second defendant applicant filed 6 paragraphs further affidavit on the first day of November 2022, deposed by one Esther Owaifo, a litigation officer at Akinlawo and Ajomo, counsel to the defendant applicants. Learned counsel to the defendant applicants also filed a reply on points of law, wherein counsel reiterated his position on the status of the applicant. Resolution. Upon careful consideration of the facts and circumstances of this case, the submissions of counsel in support and in opposition of the grant of the instant application, the court distills the issue below for determination, and that is, in the light of the fact of this case hitherto, is this application meritorious and such that should be granted? One of the aims and purpose of all the rules of court is the attainment of substantial justice with ease. See the case of Akonde versus Jegede, reported in 2020, Asika versus Atuanya, reported in 2013, citations all supplied. There are also plethora of decided cases that lend credence to the importance of obeying rules of court. Infidelity Bank PLC versus Moyen, reported in 2012, it was held as follows, and I quote, "All rules of court should be obeyed and followed. This is because rules of court are helpful in regulating prosecution of cases in court, such that they occupy a place akin to a roadmap for the quick, convenient, fair trial and orderly disposal of cases. Rules of court are part of the support system in the administration of justice," unquote. Similarly, in Nipol Limited versus Bioku Investments Pro Company Limited, reported in 1992, the Supreme Court had the following to say with respect to rules of court, and I quote, "A court is bound by the rules of court, and except there is an alternative approach, the court cannot circumvent strict application of the rules, for the rules of court are meant to be obeyed," unquote. Can see also More Dili versus Onwuba, reported in 2021. 14 Nigeria Weekly Law Reports, page 1796. Part 1796, page 211. Just as the rules of court are meant to be obeyed, the law is well settled that orders of court also are to be obeyed in full. As such, any party who is served with or becomes aware of a valid order of court should ensure that he obeys a valid order a valid court order, and failure to obey same amounts to a willful breach. See the case of Wells-Rike versus Attorney General of the Federation, reported in 2013. In describing the importance of obeying the court rules, the Supreme Court held in Adama Tankers Bunkering Service versus CBN, reported in 2022, that, quote, orders of court as made must be obeyed until set aside, while it is not desirable for the court to make unbridled orders, and court should not do everything to put a clog on the wheel of justice. Orders of the court are to be respected and obeyed. The dignity and honor of the court cannot be maintained if its orders are treated disdainfully and scornfully without due respect, unquote. Contrary to the deposition of the claimant's counter affidavit, that this court did not state a time frame when it granted his application for amendment of his pleadings, the record of the court, which parties are bound by, clearly shows that the court in its proceedings of 10th of July 2019 ordered the claimant to file his amendment of facts within 7 days, and thereafter, upon service of the same on the defendants were to file the subsequent, consequential amended processes within 14 days. One wonders how the claimant who claims he paid default fees will pay default fees if he's not, if he was not out of time to do the needful. I'm of the respectful view that the claimant cannot complain that the defendant did not adhere to the rules of court and the order of the court, while he himself remained in breach of both the rules and the order of the court. Equity follows the law. He who comes to equity must come with clean hands. It is obvious from the facts of this suit that the claimant's delay in filing an application for extension of time to regularize his amended statement of facts has occasioned a delay in the proceedings and delay defeats equity. Payment of default fees, evidence of which is not before me, is only partial compliance with the rules of this court. The claimant and the counsel cannot respectfully choose portions of the rules and orders of the court to comply with or to do so at their convenience. It is on record that following the orders of the court on 10 July 2019, the claimant filed his third amended statement of facts on the 15th August 2019, which is over a month from the date of the order of the court was made. The claimant nor the counsel never thought it needful to file an application to regularize same. The days of technicalities may be over, but there is no better time in the history of our jurisprudence and a nation to insist on compliance with orders and rules of court, especially when doing so would not occasion any injustice. I'm of the respectful view that the claimant's third amendment statement of facts, dated 15th August 2019, filed out of time, contrary to the orders of the court, made on the 10th day of July 2019, and in breach of Order 26, Rule 6 of the National Industrial Court of Nigeria, Civil Procedure Rules 2017, thus making them irregular and incompetent. One cannot therefore expect the defendants to build on the irregularity or incompetence as it would amount to condoning such irregularities or waiving their rights to seek the regularity away. It is trite that you cannot place something on nothing and expect it to stand. This court had on the 10th day of July 2019 bent backwards, exercising its powers under Order 5 of the rules of this court to accommodate and entertain the claimant's application for amendment. The claimant, with due respect, disregarded this equitable largesse, so must be willing and ready to pay the price of non-compliance with the order and rules of court. So long as a party refuses to implement and obey the orders of the court, it cannot and would not be given a hearing in any subsequent application. See the case of Ngere versus Okuruket, the 14th, reported in 2014. The law is where a party fails, neglects to do an act within the time frame allowed by the rules of court or by the order of court, the court, for a just cause and on reasonable grounds, may extend time for doing such a thing, provided the necessary application is brought before the court. See order 57 rules 4 of the instant rules of this court. The failure of the claimant to do this, like I've said earlier, makes his third amendment statement of fact irregular and incompetent, and same is accordingly struck out. I so find and hold. On the whole, the application succeeds. The issue for determination is resolved in the affirmative in favor of the defendant applicants. The claimant's, the third amended statement of facts dated 15 August 2019 is hereby struck out for being incompetent, and I so hold. There is no order as to costs. Parties should bear their respect individual costs, and ruling is entered accordingly.
As the court pleases.
Yes.
My lord.
Yes.
My lord. There's an omission in my lord's decision. There was a payment of default, and the court takes cognizance of default. You can't pay default at the same time, be punished at the same time. It will be unfair. So the court in its ruling, considered ruling, did not consider the default. The default is listed in the first page of the filing of the third amended complaint. It was calculated according to the rules of court.
Okay. I've just said I'll probably go and check what you're saying, and I will let you know.
Okay. And if I may, my lord, this court in another case has held that once default is paid, then that in itself will permit the person to proceed in the interest of justice. So you cannot pay default and be punished twice. That will be double jeopardy.
I see.
My lord, I can't hear you. Hello? I can't hear you, my lord. Hello?
Hello, do you hear me?
Yeah, you're muted your mic. We couldn't hear you.
Okay, I've unmuted it.
Yeah.
But I hear you.
We can hear you.
Hear me? Okay, but what I'm just trying to say is that now that I've read out this ruling, don't you think I'm frontis officio this, what you're saying. But you did one thing. you did one thing out of two. Either disobeying the rule or the other. But I'm Fontis officer, meanwhile. So I don't know how we will bring it back to think about it. However, hereafter I will read it and know what to do.
Okay.
Yes.
Okay. My lord, the reason I was bringing it up to you was that it's a major oversight by the court in not looking at the default that was paid, and in accordance with the rules of court as well, that when somebody's in default, he pays the default, and that will substitute. My lord, I'm not hearing you.
Since there are two rulings, meanwhile, I'm Fontis official 1.
Okay.
Let me finish this other one. Then, then yes, we will know what to do. Now, this second one is the ruling of the court on the application dated the 5th day of May 2022 and filed on the 6th day of May 2022 by the defendant applicants brought pursuant to relevant rules of the court and the laws in Nigeria and under the inherent jurisdiction of the court, praying for the following. 1, an order of this honorable court to set aside the writ of subpoena served on several persons to produce the corporate documents of the first defendant applicants from 2012 on grounds of relevancy. B is an order of this honorable court to set aside the issuance and service of the subpoena duces tecum and ad testificandum served on Unuka nominees, the company secretary of the first defendant, and Aluta Nzewi Oyeka and Co., the external auditors of the first defendant, to tender and produce the corporate papers of the first defendant on grounds that the first defendant does not consent to send. The last prayer is the omnibus prayer. In support of the application is an 8-paragraph affidavit deposed by one Evans Okoyomo, a litigation manager in the law firm representing the applicants. The applicants in their written address in support of the application formulated 2 issues for determination, and these 2 issues are: 1, whether the documents sought by the claimant in the writ of subpoena are relevant to his claims in this suit. 2 is whether the agents of the first defendant, that is the company secretary and external auditor, can be compelled to produce the corporate papers of the first defendant without consent of the first defendant. Canvassing arguments on the first issue, learned counsel to the applicant submitted that since the claimant left the employment of the first defendant in February 2011, the corporate papers of the first defendant, which are the documents sought by the claimant in the writ of subpoena, can not, and indeed are not relevant to the claims of the claimant. Relevancy is a foundation of admissibility. See the case of African Press Limited versus Attorney General, Western Nigeria, reported in 1965. Citation supplied. That is the reprint of 12 and 16. Premise on the above, learned counsel urged the Honorable Court to find and hold that all the documents sought have no relevance to the contract of service of the claimant. On the second issue, counsel submitted that the company secretary and external auditors are agents of the first defendant, and as such, they cannot be compelled to produce documents prepared by them on behalf of the first defendant in respect of which the first defendant did not consent to. Cited the case of Farmer Kinwa versus University of Ibadan, reported in 1992. In opposition to the defendant's application, the claimant responded by filing an 18-paragraph counter affidavit on 20th June 2022, deposed by Edith Akota, a litigation assistant in the law firm representing the respondent, and a written address in compliance with the rules of this honorable court. The gist of the counter affidavit is that the paragraph as contained in the defendant's applicant's affidavit that the first defendant applicant did not consent to the tendering and production of his corporate papers by his company secretary and external auditors is false and fabricated because the defendants already front-loaded the documents and referred to same in their statement of defense. As such, setting aside the subpoena would prevent the claimant from calling witnesses of his choice to produce documents or evidence necessary to prove his case and assist the Honorable Court in a fair determination of the suit and preclude him from putting in evidence relevant documents in proof of the case, thereby interfering with his rights to fair hearing. In the claimant respondent's written address, in opposition to the application of the defendant applicant, learned counsel to the claimant formulated two issues for determination, and these are: one, whether the first defendant's motion on notice dated 5th May 2022 is incompetent and ought to be dismissed. Two, does the first defendant's motion on notice dated 5th May 2022 constitute an abuse of court process to warrant an award of punitive cost against the first defendant and its counsel? Arguments. The learned counsel to the claimant's respondent on the first issue submitted that the first defendant applicant's motion on notice dated 5th May 2022 and filed on the 6th is incompetent and ought to be dismissed because this court has no jurisdiction to entertain this application under the doctrine of functus officio, and this application, if granted, will render the entire suit null and void, and it will be in breach of fair hearing guaranteed by Section 36 of the Constitution of the Federal Republic of Nigeria, 1999 as amended. On the second issue, counsel submitted that the application filed by the first defendant applicant in this issue is a gross abuse of court process in the circumstance and should be dismissed with punitive costs against the first defendant applicant, citing the case of Deji Eremeno versus PDP, reported in 2021, 16 Nigeria Weekly Law Reports, Part 1800, page 3S7 at 403. Then the resolution: upon a careful consideration of the facts and circumstances of the suit, the submissions of counsel in support and opposition to the grant of this application, this court distills the issue before for determination, and that is there merit in the application given the circumstances of this suit? Generally, subpoenas, whether duces tecum or ad testificandum, are usually issued by the court at the instance of one of the parties to command the appearance of a person or witness to attend court to produce a document or evidence before the court. See the case of Buhari versus Obasanjo, reported in 2005, 13 Nigeria Weekly Law Report, Part 941, page 1. And also the case of Omidiro versus Ete, reported in 2011, citation supplied. However, while this court is empowered to call upon any person by
My lord, we cannot hear you. You muted your phone. We can't hear you. Okay.
See the case of Mekuye versus Carnation Registrars Limited, reported in 2021. I have critically considered the argument postulated by both counsel in their respective written addresses, and as a matter of reason, I must state, and respectfully so, that I find contention by the learned claimants counsel that this court is functions official and cannot set aside the subpoena issued by it. A court becomes functions official when it gives a final decision on a matter before it. This means that the court's judicial duty or function has been wholly accomplished, and it thereby lacks further judicial authority or legal competence to revisit or review its judgment. See the case of Obo versus NFL Limited, reported in 2022. Once a court delivers its judgment in a given case, it thereupon becomes functions official and cannot therefore reopen it in whatever guise, except of course in the event that there was a circumstance where the doctrine of sleep rule applies, or to correct mistake. It cannot vary the judgments afterwards so as to give effect to its meaning or intention. See Itogu versus LPDC, reported in 2018. Subpoena are not judgments of a court, which once issued renders the court functions official, though they may be seen as orders of court. They are such that may be varied or set aside for good cause or reasonable grounds. By subpoena, the court can compel a witness to lay aside all pretenses and excuses and appear before it, either to give evidence or produce a document before the court. And the court has the power to set aside a subpoena issued if such a subpoena is not necessary to obtain any evidence relevant to the trial. See the case of Obi Odu versus Duke, reported in 2006, and also Nata Allah versus Gabapa and another, reported in 2018. Citations both supplied. On the power of the court to set aside a subpoena, the Court of Appeal in Obi Odu versus Duke Supra held, and I quote him, a person served with a subpoena has the right to apply to the court to set it aside on the ground that the subpoena is not bona fide required for the purpose of obtaining evidence that can be relevant, and the court, on application, will interfere where it is satisfied that its process is being used for indirect or improper objects. See also R versus Aguna, reported in 1949, 12 Waka, 465. Similarly, in African Press Limited versus Ayo Ojewumi and Attorney General Western Nigeria, reported in 1965, it was held that, quote, where a subpoena is applied for on a frivolous ground, it may be set aside by the court on a motion brought for that purpose, as it was done in R versus Aguna in 1949. The same applies to subpoena, which is bad for vagueness. A person served with a subpoena has the right to apply to the court to set it aside on the ground that the subpoena is not bona fide required for the purpose of obtaining evidence that can be relevant, and the court on application will interfere where it is satisfied that its process is being used for indirect or improper objects. It is clear from the foregoing that a court has the power to set aside a subpoena, provided there are reasonable grounds to set aside such a subpoena, and I so hold. In accordance with the request of the Claimants Council, that this court should view Section 184 of the Evidence Act 2011 alongside Section 185 of the Evidence Act 2011. I have considered the said sections of the Evidence Act, and it is clear that there is a nexus between Section 184 and 185 of the Evidence Act 2011, as postulated by the Claimants Council in this case. Section 184 makes provisions for non-compellability of a witness who is not a party to a case to produce title deeds or other documents belonging to him unless he agrees in writing to the production of such a document. On the other hand, Section 185 clearly makes provisions for non-compellability of a person to produce documents in his possession, which any other person would be entitled to refuse same if it were in his possession, unless the other person consents. Section 184 of the Evidence Act envisages that a witness who is not a party to a case cannot be compelled to produce title deeds and other documents belonging to him unless he consents in writing to such production. On the other hand, Section 185 further shows that even if the documents is not in possession of the owner, a witness who is in possession of such documents cannot be compelled unless and until that other person who, if he was in possession, would be entitled to refuse or produce those documents, consents to its production. However, while there exists some connection between Section 184 and 185 of the Evidence Act, I'm of the humble view that Section 185 need not be read alongside Section 184 before it can be applicable. I do not think it is dependent on Section 184 solely. This is because Section 184 specifically deals with production of title deeds and other documents relating to any property held as a pledge, mortgage, etc. On the other hand, Section 185 seems more encompassing as it accommodates all other sorts of documents. This can be gleaned from the very first line of the provisions of Section 184 of the Evidence Act 2011. It then means that the applicability of Section 185 of the Evidence Act 2011 is not dependent on Section 184 of the Evidence Act 2011. By the provisions of Section 36 of the Constitution of the Federal Republic of Nigeria, 1999, a party is entitled to adequate facilities to aid the preparation of his case. The stage of preparation, investigation, and discoveries are vital in building up the case for the litigant. Where the litigant desires documents of his opponent, he must be allowed the benefit of such inquiry. Such circumspection dictates some allowance to the litigants at that preliminary stage, see Obiolu and Duke Supra. It is on the above premise and on the overall interest of justice that the court usually issues subpoena at the instance of a party who applies for some of same if it will be instrumental to the success of his case. The defendants have argued brilliantly, relying on judicial authorities, that where a subpoena duces tecum is issued, the documents sought or rather ordered to be produced should be relevant to the case of the party that sought for its issuance, as relevancy is the foundation of admissibility. I cannot agree less with this submission. However, it is clear that the relevance of any evidence is for the courts to decide. See R versus Aguna Supra. It therefore appears that the courts must look at the contents of a document vis-a-vis the facts pleaded to determine its relevance. While relevance is cardinal to admissibility of documents, at this stage, what the court looks at is whether the subpoena contains documents that are bona fide requirements for the purpose of obtaining evidence that can be relevant. See the case of Odeni versus Onalaja and another reported in 2017. Now, the phrase bona fide means good faith. It could also be defined as absolute absence of bad faith. Also, it denotes honesty without fraud or coalition or wrongdoing. See the cases of Space versus Oni, reported in 2016, Shoda versus Registered Trustees of Ahmadiyya, reported in 1983, and also Animal Shao versus Olojo, reported in 1990. All citations fully supplied. In Obi Odu versus Duke Supra, it was held inter alia that, and I quote, the interest of justice will be better served if the court allows a party to a suit commanded to produce documents in his possession by a subpoena to obey the subpoena. At the conclusion of hearing of the case, the court will have ample opportunity and unfettered rights to determine whether the documents subpoenaed are relevant or not. Notwithstanding Leonard Seal's contention that the claims of the claimant centers on wrongful termination, and on the notes, and on that note, it is employment contract that forms the bedrock of setting such employment and employee disputes. I must state that going through the claimant's pleadings, his claims are not only centered on wrongful termination, they include other claims. Should the claimant request for documents not related to his case or linked to his pleadings, he does so at his own peril. The fact that these documents possess the date of determination, possess the date of termination of the claimant's employment, in my respectful view, does not foreclose their being used in court or make them irrelevant once they arise from the pleadings of the court. It does appear that the defendants do not have any challenge with regards to production of documents preceding the termination of the claimant's employment in February 2011. The defendants, however, did not outline or enumerate these documents. They protest are not relevant, but left this duty to the court. I have gone through the subpoena dated 4/4/2022, issued to the first defendant, and observed that there seems to be only 2 documents post-dating February 2011, an email trail from 23rd March 2016 to 15th May 2016, a solicitor's letter dated 18th June 2016. I do not think, and respectfully so, that it would be appropriate for this court at this stage to determine or look into the relevance or otherwise of these documents, as it would tantamount to delving into substantive matters at interlocutory stage, which the law frowns at. On this note, I find that the defendants and the several persons served with the subpoena should, in the interest of justice, obey the subpoena issued by the court. I so find and hold. Prayer number 1 of the defendant applicant's application fails and is accordingly struck out. As regards the applicant's second prayer, the law is well settled that a subpoena issued to an employee may be set aside on the ground that the former does not have his employee's authority to produce the said documents. See the case of former Kinwa versus University of Ibadan, reported in 1992. In this case, the Court of Appeal held, and I quote, "The law forbids a party from compelling a witness to produce a principal's document. It is thus not the law that a secretary or a registrar of a corporate body, such as a university, can be compelled by subpoena duces tecum to produce the university documents where the members of the university council have forbidden him to produce or have not shown to have consented to producing the university document," unquote. Therefore, where documents required are in possession of a company, the proper strategy is to serve the subpoena on the company itself and then requiring the appropriate officers to give evidence and protect and produce documents. There is no doubt in this case that Bunuka nominees, the company secretary of the first defendant, and Alata Nzewi Oyeka and Co., external auditors of the first defendant, are both agents of the first defendant. Therefore, the subpoena commanding them to produce certain documents can only be obeyed if the principal, that is the first defendant, consents to send. Section 185 of the Evidence Act 2011. Although the claimant argued that since the corporate documents are already made public and concerns the claimant, as they were front-loaded alongside other documents in the defendant's pleadings. The case of Famakinwa and University of Ibadan and Obi Odu versus Duke are not helpful in lending credence that the claimant's position of being entitled to uninhibited and unfettered access to documents and other facilities in the custody of the person other than the defendants on grounds of their hearing as guaranteed under Section 36, one of the 1999 Constitution of Nigeria as amended. The law provides different avenues for a party to bring before the court documents it thinks are relevant and vital to aid the just resolution of the determination of the suit. The claimant can explore these options. There is no indication that the defendants, particularly the first defendant, gave his consent to his company secretary and external auditors to release documents belonging to it in their custody to anyone. It will therefore run against the spirit and letters of the provisions of Section 185 of the Evidence Act 2011 to compel Bunuka nominees and Alata Nzewi Oyeka and Co. to produce documents belonging to the first defendant in their possession without the first defendant's consent. On the whole, this court finds merit in part of the instant application, and same is granted in the manner stated below. A, prayer number 1 fails and is hereby refused, and I so hold. The application is set aside. The writ of subpoena served on several persons to produce corporate documents of the first defendant applicant from 2012 on grounds of relevancy is hereby struck out. Prayer 2 succeeds and is accordingly ordered that the issuance and service of the subpoena duces tecum and ad testificandum served on Bunuka nominees, the company secretary of the first defendant, and Alata Nzewi Oyeka and Co., the external auditors of the first defendant, to tender and produce the corporate papers of the first defendant is hereby set aside, and I so hold. That is the ruling, and there's no others to cost, and parties are to bear their individual costs. We have to take a date now. This doesn't close it. How do you stand on the 4th of July?
Oh, July. It's convenient, ma'am.
Very well. Is that convenient for both of you?
Yes, my lord.
Yes.
Yes, my lord.
So the matter is therefore adjourned to the 4th of July, 2023 for continuation of hearing.
As the court places.
For hearing, actually. For hearing, yes. No.
Madam P.